Okay. All right, Ms. Wood, anything else?
No, Your Honor.
Done. All right, Mr. Sexion, you are free to go. Oh, you have a couple folks here. Who are you to Mr. Sexion, just so I can tell him? All right, your grandmother and your sister were here in court for you, sir. And they say hi. All right.
Thank you.
Bet. All right. Okay, that gets us to Mr. Johnson, who has 3 cases. Who is handling Mr. Tracy Reeves on the call? Fantastic. And let me get, good morning. Mr. Johnson, are you in, let me see, 1 North, you raise your hand? Yep, there you are. All right, hold on a sec. And I just need to.
Yeah.
What do we hear from Mr. Abate? Did you wake him up?
Barwick's court report as soon as he's done.
Okay, great. All right, Mr. Johnson, we should be able to hear you now. Can you hear us?
Yes, sir.
Great. We've got Mr. Reeves, your lawyer, and his guitars on screen as well. You should be able to see him. And this is a status conference. You've got 3 cases with me, a bunch of burglary allegations. I guess I want to know what we're doing to move your cases forward. Mr. Reeves, I'll start with you.
Thank you, Your Honor. We've received discovery on 21 SC 179244, and we have reached out a few times. I know it's switched prosecutors at least twice since I've had the case, but on the outstanding 21 SC 179243 and 21 SC 179391, we haven't received any discovery other than the indictment. But as soon as we get if we can get those this week, it's not going to be a trial. We're just trying to make sure we have all the evidence before we can have any discussions with the state.
Sure, very reasonable request. Query Ms. Charles, who's here in court and is going to be the prosecutor who sees this one through. No more musical chairs. In the position 7 on the calendar, it lists a bunch of CP cases. Are there also unindicted matters for Mr. Johnson, or those basically were swept up into one of these 3 indictments, if you know? I know you didn't.
Last look, I believe they were swept up. I was going to just confirm real quick. And
Okay. Do you know, Mr. Reeves? I'm just noticing in the calendar, it lists some unindicted matters.
From what I see, the unindicted matters, I think, are separate from what was indicted.
Okay.
see.
And I flag that only because you may want to make sure that all of Mr. Johnson's business is taken care of. So I think part of Ms. Charles's homework will be to get you your discovery in the 243 and in the 391, but also to see if these are also burglary in the 2nd degree. That seems to be the thing here. Pardon me? Open. Okay, no, they've all been consumed by the indictments. That's good.
My recollection is that we had sent all the discovery, but I'll go ahead and redisclose. I believe we sent multiple evidence.com links with all of the video evidence and
Okay.
and we got an email on 5/24 asking to have the discovery sent over again because there was an issue on Mr. Reeves's, I guess, assistant's part to save some discovery on their system.
Okay.
So I'll get all of that out to him again. I had my assistant last week send the email to her, 5/24, asking her to redisclose everything.
Okay. I'm looking at the 391 case, which has the 19 charges, and there isn't anything in the docket that suggests that one of your colleagues provided discovery. The case was indicted and then very quickly transferred. Let me see. Judge Barwick kicked it to us because Mr. Johnson had those older cases. So I'm not saying you didn't provide discovery, but there's nothing in the docket. Usually then you also file a certification that you sent something.
Okay, that probably been my error, because I do have an email dated 12/6/2021 when I sent all the discovery directly from myself to Mr. Reeves by email,
Okay.
as well as the links. So
Great.
I'll have my assistant do it formally.
Okay, and 12/6 would have been when Mr. Reeves opted in and filed his entry
Yes,
of
sir.
appearance. So why don't we have today be the nudge to both sides to reconnect, Mr. Reeves and Ms. Charles, to make sure that Mr. Reeves has got the discovery. And Mr. Reeves, I don't know if you could hear Ms. Charles, but she's saying her records show that she did send things, but things these days are often just a link. And then you get to a place at evidence.com where you can download body cam video or surveillance footage or whatever the district attorney's office has amassed as discovery. It's not, we mail you a stack like this or we mail you some DVDs. It is now much more. So here's a link and download, and you can print what you want. You can save what you want. If you have technical issues with that, please do reach out to Ms. Charles so that she can help you navigate it.
And she's correct. That was the issue. I was able to download obviously one of them, and then some of the other encrypted files I just wasn't able to. So I'll make sure that we get that done today.
Great, please do. How far, I don't want Mr. Johnson's cases to fall off the radar. They're older, a little bit older, and per your observation, Mr. Reeves, they're resolvable. It's not gonna be a trial. So I wanna keep the pressure on the two sides. When should we put this back on a calendar? You know, is a month too far? Is 2 weeks too far? Or what do you need?
I would request 2 weeks. As long as we can get everything today or tomorrow, then 2 weeks would be more than fine.
Okay, and I don't want to be clear, I can't guarantee we've got a spot in 2 weeks, but that helps me work with Ms. Nelson to say, let's get this on the next available, and next available will not be tomorrow. So we're not going to waste everyone's time. It's like, hey, good to see you again. What'd you do yesterday? But we will aim to get it. We'll call it mid to late June. And Mr. Reeves, if it's going to be a plea, do you want Mr. Johnson in person with you in court? Do you prefer Zoom? Because we can structure that in different ways.
I'll get with Mr. Johnson, but probably in person.
Okay, good to know. Just let Ms. Nelson know that, but I'll make a note of that.
And if we do reach a resolution, Your Honor, do you want me to reach out to get all the paperwork in order ahead of time?
That's always better if you can. Yep. All right, Mr. Johnson, you have listened very patiently as the lawyers involved have been talking. Do you have any questions for me about your cases?
No, sir. I only have one question. Did I hear 19?
Yeah, so your most recent indictment that was assigned to a different judge and then came here because it ought to be with your older cases. That indictment, if I call it up here, has, you know what, it's not 19, it's 8. I don't know where 19 came from. It's 8 counts. It is 6 burglaries in the second degree and 2 criminal damage to properties. Somewhere it said 19, and that's why I said I wasn't making it up, but don't fret. There's nothing with 19 counts. It is the 8 counts I just read. Okay.
Yes, sir. I just wanted to confirm.
Yeah, I didn't want you to panic on that. The lawyer would charge you more. All right. So I think we're all set. Mr. Reeves is going to get with Ms. Charles to get discovery, and then spend time with you, Mr. Johnson, and then we'll all get together. We'll call it in mid-June, maybe a little bit later, to see if we can resolve the 3 cases. Ms. Charles, anything else in the Johnson matters?
No, Your Honor.
Mr. Reeves?
No, Your Honor. Thank you.
All right, thanks. Mr. Johnson, you are free to leave the booth.
Thank you, Judge.
And I do believe that concludes my business, Your Honor. Or maybe excuse.
Yes, sir.
Thank you. Good to see you.
Same. All right. Mr. Lassiter, we are still waiting on the major case prosecutor. So we're going to leave Mr. McKinnon right where he is. We'll get Mr. Abate in here as soon as we can. And I think we'll see if there is anyone else on the Zoom call who's got something that we could do. Let me just make one more note. All right. So the plea and arraignment at 10, that's a walk-in? It's not?
Yes.
Okay. So folks aren't late yet.
We're now on top of it, but not the calendar, that's the notification now. That's on.
This is for the jail one.
Right.
Okay,
The jail back.
good. No, the jail's done a great job. A+ to Captain Betts. Okay, because we're going to say we had Mr. Lassiter and we have Mr. Reeves. Okay, we're not treating our regulars well.
Thank you, Judge.
So Captain Betts, we're going to sit tight. I know we still have Mr. McKinnon in 6 North. We're just waiting on the major case prosecutor. And that's on us. We didn't push the calendar out to the DA's office or the public defender's office.
No problem, Judge.
Thanks. Is anyone? Yes, sir, Mr. Lassiter.
No, Mark Mallon.
Oh, Mr. Mallon. Yes, sir.
I'm standing in for Ed Adams. While we are enjoying the lowering clouds, he's in Provence. And
He charges too much. All right.
it's not coming my way. But anyway, he had represented Earl Ward, I guess, and Wade, that's it, in an underlying case, but he was not retained for the probation revocation.
Okay. Well, let me ask the PD's office. That's a 1:30 calendar. So Mr. Wade is probably here, but if he's not up, that's not an issue because we weren't going to tackle that till the afternoon. But let me ask, Ms. Wood, is that something that your office positions 3 and 4 on the probation revocation calendar? Earl Wade. It doesn't list your firm. I mean, it doesn't list you, or I don't know if Tiffany Smith may have been someone from your office way back when.
One moment, let me just check. So there's the new case, and it looks like our office is representing the co-defendant on the new case.
The new case. What's the new case?
So the charges-
Oh my gosh, look at that. I
That's
see there's a CP case with a pretty serious allegation.
Yes, Judge.
Let me look that one up. So, Mr. Raffoff is from your office?
Yes, Judge.
Okay, so you represent Gentry, Wade. No, all right, so there's no, we're gonna need to get I guess that's gonna be Mr. Theory.
Yes.
All right,
He's on trial.
he is, I saw that. That's not convenient. Okay. There's Earl Wade. Okay. So Mr. Mallon, my guess is we'll need to reset this anyway. Mr. Wade is in jail with no bond on a murder charge. He has no attorney on that case right now. He cannot have the public defender because they have Mr. Wade's co-defendant. So we'll need to reach out to the conflict defender who's not available today. And I guess I can explain all that to Mr. Wade at 1:30 when we do that calendar. You're welcome to Zoom back in then, but I'm also happy to explain to him that he's going to, most of all, if he doesn't want public representation on his new charges, he'll need to retain someone. And my guess is we're going to put the brakes on this revocation until we get Mr. Wade a lawyer on his new charges.
He's muted, Judge.
Yeah, Mr. Mallon, anything you want to add to that?
Yes, Your Honor, it would be convenient if you could do the explanation because I have other matters this afternoon. And my only announcement is it ain't us.
Right, got it. I can say that it won't be as eloquent, but I will let them know that when we get to that calendar. So you go tend to your other matters, not in Provence, and hopefully Monsieur Adams decides to return.
Very good. Thank you, Your Honor.
You bet. Bye-bye.
I know.
Judge, Jewel Lasseter here. I don't know how long this is going to take. I just kind of wanted to bring recognition to the fact that Mr. McKinnon's mother and sister are in the courtroom. I don't know how long they're going to be able to stay. I just kind of wanted you to know that they were there just in case they have to leave for whatever reason.
Sure. Let me see who's here for Mr. McKinnon. We got a whole bunch of folks, including Elmo. We got 5 people here. And I don't want to make people wait anymore either. Again, through no fault of yours or the district attorney's office, the prosecutor didn't know to be here at 9, and he is in front of another judge, not for trial.
He didn't say, Your Honor.
He didn't say. Okay. Let me. Okay. I'm just getting Mr. McKinnon's case up here on my screen. All right. Well, I'd like to hear the bond. Your motion has been pending for a month and a half now.
Quite a while, sir. Judge, did I hear you correctly? You want me to hear the bond, or are you just going to still wait? I just want to make sure.
No, I said I would like to hear it, but it takes 2. I can't just hear from you. I need to hear from the state.
I just want to make sure. I just want to make sure I wasn't misunderstanding you.
Yeah.
But it has been a while. No.
He's done signing, so he's next up. So I just next to his ETA.
Oh, so it's Tuesday, so she has that bond calendar. Okay.
Instead of around 10:15.
All right, Mr. Lassiter, we heard from the prosecutor who is in front of another judge and will be until about 10:15. We will stop what we're doing with our 10 o'clock calendar once Mr. Abate gets here. But I would like to do the bond hearing today rather than reschedule it. I don't know what the family schedule is, but I can certainly make note of the fact that Mr. McKinnon had meaningful family presence, and they may be able to stay till 10:15. I'm not requiring that, but I'm getting some nodding heads. So it sounds like they'll stay here. And once we get our prosecutor, like I said, we'll pivot back to Mr. McKinnon, okay?
Thank you, Your Honor. I will mute my audio and be back in about 20 minutes, 15 minutes.
Sounds good. Thanks for your patience.
Yes, sir.
All right, I'll come back out, I guess, at 10, and we'll do the plea and arraignment. You all got the plea and arraignment calendar? Okay, all right.
Because I think they didn't have their. Okay, I think it's directed by.
You want to come back?
That's the person. Who has the code.
Mr. McKinnon, you can step out, but be back in about 10 minutes.
Yeah, yeah, so that would. Yes, sir. Thank you. Is Sean here? Is Sean also do this? And then Mr.
Was it locked over there?
Receive no calendar, you got the Outlook notification.
I
but there was
didn't get
no-
an Outlook
I don't know
notification
that
for
I
it.
did. We talked about it ahead of time. We're like,
Because
let's
the
go ahead and
booth,
check.
I had the booths and everything.
I didn't get it.
But it didn't have a calendar attached, but it was the Outlook notification.
Oh,
So I thought that maybe you guys, well, it was not it, I'm not saying that. But
Yeah, like I had the other three. I came early because I wanted to talk to clients. So like luckily, like,
I was like,
yeah, we
all the
talked,
calendars,
right,
like,
we go through them.
and the victim called me at 1 o'clock. I'm on my way. I'm like, I'm on my way.
I am so sorry because
Yes. So we like watched it at the same
so the
time.
private attorneys got, because, so I was like.
So bizarre.
So it was, I looked and I saw Outlook, and it's like, I marked, and I said, when I emailed, and I went back and I looked, and I said, I see it. Notification, because I had to ask the
Right.
boom to the
Oh.
all the booths. I had to-
Right.
No, there wasn't a calendar, there was not, that calendar was not attached for the 9 o'clock, but I assumed that you guys said, oh, she just started at 9, but our calendar really starts at 10.
Oh, no. Yeah, I was like, what is happening?
Oh, no,
Okay. It's all good. Yeah, it wasn't a bad calendar at all.
okay.
Got it.
Okay, my apologies, I'm sorry. Okay.
I'll step out just one direction.
Yeah, that's fine.
Welcome.
Hey, Gordon, so the rest of those people walk in.
Yeah. That calendar, we got everybody else doing stuff.
Oh, yeah. You don't be looking.
No, it wasn't me, it was.
Oh. Oh.
She is so big. It's like 15 minutes. She's so big. Yeah.
I know. She's so funny. No, they came to me. I was gonna go, but you know, my life went on my car and it's a difficult one. My cousin has things going on, so he was a day late on me. We'll come out. They came out and played. Just for the day, but it was nice. So that's it. Okay, well, the rest of the people basically walked. Okay.
So, yeah, so we were like the code so yeah, we went in and addressed that, but we'll probably talk about it again this afternoon.
Oh, so it's not just legit. Oh, okay. Oh. Yeah, I didn't know. There's a file.
Okay. So it's just on the arraignment. I don't think Kathy is the prosecutor on that, and I think Kay might be standing in for her. Okay. So she's here. Okay, great. So yeah, so that could just be a waiver, not guilty, whatever. But yeah, she is present, and then this is just short. Yeah, because it's like short, and then like the one that's your only one on this card. Okay. Yeah. Miss Jones. Remind me, are you a rising 2-0 or 3-0? Rising 2-0. Okay. And you go to NYU, right? Yes. Okay, awesome. Do you have, are you from Georgia? Where are you from?
No, I'm from Phoenix.
Okay.
Yeah.
So how did you end up here?
Yes. So my boyfriend is in med school at Emory.
Amazing.
Yes. So it was just, I wanted to work in PD this summer and it worked out.
Yeah. Perfect. That's
Yeah.
so cool.
Yeah.
You're assigned to us and who else?
So I'm working with because Marilyn's your supervisor.
Yes.
Yes. So then I'm with Luana Walsh and one of her attorneys.
Oh, sorry. Sorry. I'm chatting.
There's nothing that I'm missing.
That person's here. Please don't know. I think that would just be like a waiver. And then that person, if he shows up, I'll talk to him. I love that you know who it's at. I went ahead and waived this one, but I think it just got filed this morning. I had to do it last week. And then I'm gonna see if he, I would like to see if we can do it. Okay, yeah. And I do expect him, so I'll talk to him and then I'll get back with you. And then this one, I think that would be higher. I'll double check though.
I can see it.
And then that one will be a conflict because we just picked up the co-defendant on the 90th count. So yeah, it should be a short one. Thank you.
Tanya Jones.
Oh, okay.
Yes.
Nice. Have you been to court with her yet?
I have not even met her yet.
Oh, cool.
Yes. So I'm actually,
Court?
yes,
Oh, yay.
yeah.
Well, welcome.
Chaotic.
Mr. Horton? What's your name? Okay, Mr. Chandler? Ooh. Right.
That's right.
Hey, how are you? They're already here? Oh, amazing. Okay. Who do you have?
Tory, Wallace, Tolbert, William,
Oh, sweet. Okay.
Daniel, Sherry, Paul,
Ooh, yay.
Ransom.
Oh my gosh, I think that's all of my people. Okay, I'm in a rush. Okay, yeah, once we get done with this calendar call, I'm happy to pop back there because I was hoping I could talk to them before one.
Okay.
Awesome. Thank you so much. Right. Okay, yeah, no, I'll definitely talk to them afterwards. Thank you. Do you know if any of the 1:30 calendar people are here? Okay. Okay, that's fine.
Are some of the 1 o'clock people here?
Mm-hmm.
No, no.
So excited.
We'll probably get him for.
Okay.
Yeah, we'll get her.
Okay, thank you.
You can't hear me? I hear you, Tiny.
Okay, so
Say hey, Dada. Hey, baby. He's sleeping. Mute it, Tiny.
Okay. Oh, okay.
So yeah.
So Ricky Wolf, we just got his murder case because we didn't resolve his 3 other cases first. So Harrison Trim, we may want to try to work out Harrison Trim so we don't pick up other cases. We just got a 2 defendant murder case because we didn't work out Ricky Wolf's old cases. All right, do we have an update on Mr. Abate? I guess it's not quite 10:15. He's got 3 more minutes. Let's see what's going on with our 10 o'clock plea and arraignment calendar. Is Michael Jones here?
Jones is here. That'll be later this morning.
Okay, and is it Michael or Michelle, or it's Michael Michelle Jones?
It's Michael Michelle.
Great. All right, Ms. Jones, it's nice to meet you. Let me check one thing here on your case. Who will be handling that for the state, Ms. Charles?
It's 88, I think it's 88 Buttonhauer, 88 Cassie Hall was standing to, she's not well.
Okay, so right now are long-term, Hall, medium-term, you, short-term. Family of prosecutors. All right. So Ms. Jones, I just wanted to call up the bond to make sure. So there's someone you need to stay away from. That's not been a problem. Can you stand up? I can't hear you.
The person I need to stay away from is my daughter's grandmother, so it is kind of a problem.
Okay, Ms. Hightower, that's your daughter's grandmother? Got it. And that's a problem because she is a care provider for your daughter, or just it's a family member?
It's a family member, and her dad filed for custody recently, so she does interact with her grandmother.
Okay, well, just talk with Ms. Feely about that. I don't want you to run afoul of your bond, and I don't know the dynamic, but I don't want you to get stuck in a trap. I don't mean that in a sense like a bear thing clomping on your leg, but it might be you're just simply getting your child to see her father, and then Ms. Hightower is there and someone takes a picture and you're in trouble. It maybe that's not the dynamic and people are getting along well enough. But you just need to be careful about that until your case is resolved or Ms. Feely gets the bond conditions modified. That's the kind of thing that could get you in trouble. And if the state comes to me with evidence that Ms. Hightower feels like you've been in her space, that's the kind of, that would be a reason to take away the bond. And I say that not to threaten you in any way, just to caution you to make sure you're navigating that safely. But again, Ms. Feely can give you counsel on that. Okay. So Ms. Feely, you're waiving arraignment, and you'll file an entry if you haven't already. We'll get a scheduling order out and someone from the DA's office will get you discovery.
Yeah.
Okay, great. Do you need Ms. Jones to stick around?
You've already spoken, and I'll be.
Okay, you've got her contact info. All right, so Ms. Jones, you're free to go. Thank you for being here. Any questions for me? Okay. Michael Chandler. Any reason we think Mr. Chandler would not be here?
Judge, I don't believe he's been arrested yet. I'm just
That would be a reason.
When I put the body camera and I started giving him the citation.
Oh, yeah, that's right.
While he was in sort of medical freight truck.
Okay. So what do we do with Mr. Chandler then? How did he know to be here?
He was on this citation of the charges and the address that we have on the system is accurate. He's in sort of a boarding room house. So to rehabilitate and treat. So I don't know that he wouldn't have gotten notice.
Okay.
Incident was back in April 2021.
Okay, so the incident's about a year and a month old.
Judge, I would ask for a reset just to see if we could try to, there was no number that we could find when I first looked, but if I could have an investigator try to track him down, I would like to try to do that before a warrant is issued.
Okay, why don't we do one reset? It looks like the alleged victim was an occupant there as well, and then maybe there's a witness. So your investigator may be able to go to that address to say, anyone have the latest on Mr. Chandler? So we'll do one reset and then take it from there.
Thank you, Judge.
Sadiq Parker.
Judge, this will be mine. I filed a waiver. He had work this morning he was unable to get out of, so I have good contact for him and we'll enter a plea of not guilty and just get that schedule in order.
Okay.
Who's the EDH?
That will also be Whitenauer Hall.
Yes.
Okay. All right, we'll do a scheduling order. Nicholas Horton. Right there.
Judge, he'll be mine. If we can hold and come back to this one, ADA Charles and I have been speaking about this, and I do want to speak with Mr. Horton to see if we can't work this one out.
Fantastic. So Mr. Horton, sit tight. We're going to be through with this calendar in just a minute, and then Ms. Wood will be free to talk to you, which she'd like to do, and then we'll see what we do next, okay? Great. Oh, actually, Mick Burrows, we'll see what happens. All right, Cortez Gibson. Don't see him. I don't see Ms. Griggs if she's still on the case. Uh-oh. Let me look this up. It was a what?
It was an old case. Incident.
Oh, yeah.
Happened in August of 2000.
Yeah. But he got a big old bond. All right, bench warrant. And now we've actually got the co-defendant of one of our cases this morning, I think it's Mr. Sexion's co-defendant. Avriana McBurrows. Nope. All right. Ms. Wood, you or Ms. Feely are handling Sexion, is that right?
Yes, sir.
Okay, so that's PD. So this person would need a different lawyer.
Litigation manager just emailed me, said how it should be pushing.
All right, thank you. All right, bench warrant. So, Ms. Wood, if you want to spend some time talking to Mr. Horton, now's a great time to do that. And I will come back out here as soon as Mr. Abate gets here. The judge in front of whom he is arguing bond just said he's almost done. So he should be here shortly. And it's just down the hall, so it's not a long commute.
No problem. I'm standing by, Your Honor, very patiently.
Excellent. You are very patient. I appreciate that. That doesn't mean you're necessarily getting bond for your client, but I do appreciate the patience.
Doesn't mean that I'm not either, Your Honor.
This is, well, I can guarantee that you wouldn't if you went away. You're right.
I'm good. I'll be prepared when he shows up. Thank you, Your Honor.
Great. All right. Thank you.
Hey Judge, are you gonna need his criminal history for the bond? I can go and pull it while we wait if so.
That'd be great. Yeah, I did read the report you all generated when he was booked in, and it referenced something in Cobb and something else. So if you don't mind just grabbing that, that would be great.
His name.
Thank you.
What's his client's name?
Pardon me?
His client's name.
It is, I don't know if you got that. You may not have gotten the calendar because this was the mystery calendar. His name is David McKinnon, McKinnon. You want the booking number or indictment number? What else will help you?
Give me the book.
Booking is 2204498.
Okay.
Thanks. Yeah, it was an ankle monitor guy. It's been indicted, or it's because I couldn't find a bond where he got an ankle monitor on it. Yeah. We're gonna try to create a not a calendar, but a spreadsheet that Ms. Green, who does the competency thing, maybe she is the one who has a list of everyone on an ankle monitor, so that then the ankle monitoring company can just reach out to her and say, hey, there's a problem with this case. And then she can get with the litigation managers and people can have a chance to respond rather than we get an email saying we turned it off.
So I don't even know why.
I couldn't find anything that required him to have ankle monitor. Right. 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 Because I found that case, but it was closed. And I couldn't find anything that was open. And the booking number they had was missing. Good luck. All right. Okay. Thanks for your patience.
Day. Hey, Day.
What's up, y'all? God, granddad.
The question, mucho still. Canned fruit, canned vegetables, canned air for ice for those
gang case too. This one that we got.
Just wait until that other person wakes up. You will get.
What did Melnick have for this afternoon? Is he on the status or the revocation? Oh yeah, Mac Ransom. Hope his mom's okay. And I don't remember if this is one of our first ones of these. Are we bringing people over for the status conferences? Or they? Well, some of them, like number one is.
Yeah, because today's transport.
Okay.
I think I'm trying to remember.
Let's see.
So these are the
Mm. Yep. So Deputy Gordon, you're wearing long sleeves and mourning. I'm disappointed. I don't get lunch. I'm assuming you're not gonna bet on the Celtics.
Oh, definitely not.
Yeah. I think it'll be 6, but either way, I thought maybe you guys could do it. 4 points, at least it was close. Oh, well. They had a good run.
So do you have an announcement for Mr. Horton's case?
Nicholas Horton, yes, ma'am.
So I think it's probably for today. I'll just enter the waiver, plead not guilty, but Ms. Charles and I are working on something. I just need Ms. Patterson's help on this one.
Okay,
I will be updating Mr. Horton's address as well.
okay. How did he get notice to be here today?
I do know our office spoke with him last week, so I think that was it. I was also texting him, Judge.
Okay, great. So you helped get him here in the sense of letting him know there was court. So Mr. Horton, I got an address for you in Jonesboro. You don't live there anymore? Yeah. Okay. So we may have the good address. I don't know. What did he?
That is it, but he thought there was an older one in there. So.
Okay. No, it lists 9415 Windy Court.
Perfect.
Good. So we're current there. So waiving arraignment, you'll file an entry, and then it sounds like there may be a resolution soon. You need to get with Ms. Patterson to see what she can help line up.
Yes, Judge.
Okay. All right. Mr. Horton, any questions for me? Ms. Charles, will this be your case?
Sure.
All right. Well, if you all do sort something out, let us know so we can get it on a calendar. Otherwise, if there are no motions, it won't appear until we do one of these status calendars like we're doing this afternoon, and that's a little ways down the road. So you can have an outcome sooner if you just let Ms. Nelson know.
Yes, Judge. Thank you.
All right. Do you need to talk with Mr. Horton anymore, or is he free to go?
He's free to go, Judge.
All right. Thank you, sir, for being here. All right. We continue our wait for our prosecutor. Let me know when he gets her.
Can I ask you something? So. Miss Bryant, so. Miss Bryant. So she's coming. Yeah. She's coming, so it says adjournment. Also known as. But when I'm pulling her up in 30 or whatever it is, yeah, but it's two different UPIs. And it's two different birthdays, but one's Bryant. So do you guys have that in the records too? Well, I know that, I already know that she's this person under this booking number. So you're not saying she's two different people, you're saying. Yeah, I'm not saying she's two different people, but it has literally two different, cases in Florida. And so just put that in your Bryant and one. Right. But it has anything. Right. So she's been arrested on both. I think that's one of her aliases. The only reason I ask is because on one of them, like the 19, a C's coming up under Bryant. And then Harris County, Big County. We'll see, the way this one is indicted, this one right here, it's indicted under Linda Harris, also known as Adrian, and Bryant, also known as Adrian Bryant. So in the actual indictment, they have all three. Right, so is that an attorney? I'm not asking. I know people like Amy, but it's all like it's one column, but it's actually two different. We'll pull it up. Yes. Maybe ask Mr. Smith on that, but when I will bring her up, she has three aliases. She has one there, Adrian Bryant, and Adriana. Right. Oh, yeah. Yes. Yeah. So that's how that you've seen, and that's correct. So it could be maybe like one of her other cases, she might have been Linda. Because I wouldn't put the case down. Go back there. And it's older, so we have to go out, but the 19 SC that we're doing today is coming up under the trail line.
So I think this is your first person.
Have one.
One was the first one that she went for. She felt.
I'm gonna start on.
She was right. She was right.
And her, but.
Yes. Okay. So she said on Wednesday. Yes, I think it's with her, right? Yeah. So that would be Judge Cobbs. Yeah. Which I've actually never been important to have to. Oh, yeah, I will. When I've also been going through cases. Cases. So that's nice. That's amazing. Yeah. But I guess it was with, I think so. Yes. Yes, so that's what, no, I wish. Friday. So we're supposed to have and then there is something. Okay, so judgment, I'm just starting filling these status comments count. So basically, these are technical. If we have discovery, these cases, before they move to trial. So this is the new so that's Lee's case. It needs to prove. There's a good offer on that. Okay. Yeah, it's not. Oh, also like. There's possibility take it even if it's like, okay. Yeah, okay. I don't know if Judge Cox was in. Yeah. But that's how you. I just have this. But that's also And then the morning calendar, I think, is. Josh can check.
No,
So. Yeah. Some of the things. So it could be very interesting. And I can make sure that you guys are like this, you're interested. Okay, well, I do then come back. Because this one up with me. And because she gave me the money. Yeah, we'll run through these. Okay. Run through.
How's your weekend? No.
She was oh,
Morning. Sorry for the surprise appearance. It is on us. The calendar that has your case for the morning it went out to the private attorneys. So Mr. McKinnon's lawyer was here ready to go with the bond hearing, and everyone else was sort of surprised, but I appreciate you making it down the hall from Judge Barwick's courtroom. Let's see what's happening out at the jail. There is Mr. McKinnon. Let me get him on spotlight. Let me unmute him. 6 North. All right, Mr. McKinnon, can you hear me?
Yes, sir.
Excellent. Mr. Lassiter, you ready to go?
Yes, sir. I'd like to say good morning to Mr. Abate.
Morning, sir. Mr. Lassiter, Mr. McKinnon's family is back in court. They left to put more money on the meter, but they are all here. All the folks that were here earlier have stuck with us. Ms. Rivers, are you able to hear us?
Yes, Judge, I'm ready.
Great. Good morning.
Good morning.
So we are here on case 22 SC 181.
Miss Jenkins is here also. Marquise's grandmother, Miss Jenkins.
Fantastic. I'd ask that you not interrupt us again, but I appreciate you letting us know that you're here.
Sorry.
Thank you. That's okay. That's all right. Appreciate that you're here. All right. This is case 22 SC 181907. We've got State versus David McKinnon. Mr. Abate is here on behalf of the state, and Mr. Lassiter is here on behalf of Mr. McKinnon. Mr. McKinnon is appearing remotely. Mr. Lassiter is also connecting via Zoom, and we need to work through two things this morning. It is Mr. McKinnon's arraignment date, and there is also a motion for bond that we need to work through. Mr. Lassiter, do you waive your client's presence here in court, and are you authorizing us to proceed with your client appearing remotely?
I do, Your Honor.
And are you waiving arraignment and entering a plea of not guilty on behalf of Mr. McKinnon?
We are, Your Honor.
Great.
We would also opt into mutual discovery and ask the state to provide us whatever information they have in this matter as soon as possible.
All right. I'm sure Mr. Abate and his team will jump on that. I have worked on this case a little bit already because there is a co-defendant, Mr. Russell, and he's had a bond hearing. So I would hope the state's discovery package is ready to go. I know they've been trying to get discovery to Mr. Russell's lawyer, and now we've got Mr. McKinnon here and his lawyer. So we'll hopefully the state will get discovery flowing your way. The other thing we need to talk about is bond. So Mr. Lassiter, when you are ready, if you want to share with me why you think Mr. McKinnon is a good candidate for bond and what that bond should look like.
Your Honor, I definitely feel like Mr. McKinnon is a good candidate for bond in this situation. But before I proceed, if there's anybody here connected to the victim, we would express our condolences. I've been authorized by the family to do that. Mr. McKinnon is a local resident. He lives on Mount Zion Road in Atlanta, Georgia. He's got significant ties to the community as demonstrated by the presence of his mother and sister and other concerned family members here in court with us this morning. Also via Zoom, his infant child and the mother of that child are also here via Zoom if the court would so choose to look for them. Mr. McKinnon has been charged with several felonies: murder, aggravated assault, possession of a firearm during the commission of a felony. And I would attest, Judge, that these charges do not reflect what actually happened that night. I'll be more obliged to say more. We have already pled not guilty, and we are willing to provide any affirmative defenses available to Mr. McKinnon. He is not a flight risk, as can well be shown by his family members here. He has an infant son, infant child that's here, and he doesn't pose any threat to any witnesses involved in this matter, Your Honor. So we think that Mr. McKinnon is qualified for a reasonable bond. He is one of the richest people in our community. We just want a bond reasonable enough to assure his presence here, which he is willing to do. He's willing to show up and answer for these charges. He's anxious to get out and assist me in preparing whatever defenses that we might find. And I think Mr. McKinnon is eminently qualified to be released so that he can assist me and attend to his family.
All right, Mr. Lassiter, thank you for that. I got a couple questions, and then I'm going to get some information from pretrial services and probation, and then I'll hear from Mr. Abate. So if Mr. McKinnon were to post bond, he would live at that Mount Zion Road address?
Either at that address or the address with his mother, if that's not the same one.
Okay. So which would it be?
I would ask Mr. McKinnon to tell you that answer, Your Honor.
All right. So Mr. McKinnon, if you got bond, where would you live?
You resigned at 108. Johnson.
Can you say that again?
108 Millstone Parkway.
Millstone Parkway?
Millstone Parkway, Johnson, Georgia.
Okay. And who lives there?
I do.
Who else?
It's me.
Okay. Is that your understanding, Mr. McKinnon, that if you made bond, you'd live with your mother in Jonesboro?
Yes, sir.
Oh, sister. Sorry, live with your sister.
Yes, sir.
Okay, didn't mean to promote you. All right, and so ma'am, in Jonesboro, you live there with your kids and you let your brother stay with you? And if he had an ankle monitor so that he's pretty much at your house unless he's got a job that we can verify, that's not an issue for your household. And there's room for him. He's not gonna have to live in the garage. Okay, all right. That's helpful to know. Okay, and Mr. Lassiter, was Mr. McKinnon employed at the time he was arrested? And if so, what was he doing? And if Mr. McKinnon needs to answer that, that's fine. I just want to funnel everything through you, so I'm not questioning your client.
I appreciate your honor. I do know that Mr. McKinnon was employed. We hadn't had a chance to get those particulars. He'd be most willing to tell you about his employment.
All right, Mr. McKinnon, at the time of this situation, what were you doing to put money on the table for your little boy?
I had two jobs. I worked at the warehouse, and I had another job for a handicapped person, a healthcare handicapped person.
So you worked some of the time in a warehouse, and then you were also a care provider for someone?
Yes, sir.
Okay, was that a family member or someone you did not know?
It was a family member.
What kind of work did you do in the warehouse? Uh-oh.
I'm locked up. I think he's locked up, Your Honor.
Yeah, no, he's back now. What kind of work did you do in the warehouse?
I did sanitation.
How long had you been working there before you got arrested?
I said about like 9 months.
Okay. Thank you. Pretrial services. What do you have in terms of criminal history for Mr. McKinnon?
3 priors. Last arrest was August 2021, Cobb County. Possession of cocaine, possession of a knife or a firearm during the commission. Before that was July 2021, Cobb County. Possession of cocaine with intent, sale of marijuana. Possession of a knife or a firearm during the commission. Carrying a weapon without a valid license. And possession of a Schedule 4 controlled substance. 2018, Fulton County, simple battery, disorderly conduct, obstruction. Those are non-prosecutable. So he just has to open cases in Cobb County and a Cobb hold FTA warrant out of Cobb.
And does your information, thank you for sharing that. Does your information show whether either of those Cobb arrests has turned into an indictment?
No.
Okay. Meaning there is no indictment, or you cannot tell from your information?
I can't tell from the information.
All right. Thank you, sir. And Ms. Toussaint, good morning to you. Do you have any adult felony probation matters for Mr. McKinnon? Okay.
I'm sorry, I didn't hear Ms. Toussaint.
She said he does not have any at this time.
Thank you.
You're welcome. Mr. Abate.
Thank you, Judge.
And before you dive into it, just so I'm making sure I'm oriented the right way, we've had a bond hearing with Mr. Russell, the co-defendant. Is this the case where there's Mr. Russell allegedly initiates a scuffle over a handbag or some kind of property of the deceased, and then the state's position is Mr. Russell isn't the one who shoots, but it's Mr. McKinnon who's the one who shoots?
That's correct, Judge.
Okay.
Yeah, I think we've had 2 actually on Mr. Russell.
We did. Okay. Share what you want to share. And then, of course, Mr. Lassiter, you'll have the last word as the movement.
Thank you, Your Honor.
I am just looking up one thing for Your Honor. Thank you, Your Honor. The state would respectfully request you deny defense counsel's motion for bond. I would first submit to the court that he is a risk of flight. The warrants in this case were issued on November 18th of 2021 for the incident that occurred on August 30th of 2021. Once Mr. McKinnon's identification was confirmed, there was very, very clear video from the store that was right in front of where the shooting occurred. The actual shooting did not occur on the video surveillance for the store, but prior to it, the defendant and his co-defendant had been in the store, so they were able to get some clear pictures and be able to release those to determine the identity of Mr. McKinnon. On the video, you clearly see Mr. McKinnon with a firearm, and I bring that to the court's attention because he was out on bond for one of the Cobb County cases that pretrial, had indicated, and he was released on bond on July 22nd of 2021 by Judge Perez. And one of the conditions was that he was to have not to have any firearms. And he's clearly violating that on the video when he is in possession of a firearm. And right before this incident occurred, he was again released on bond on August 9th of 2021, also out of Cobb County before Judge Feingold. And that was both cases involved the possession and purchase of a controlled substance. And in each instance, he had a firearm when he was doing those or allegedly committing those offenses. And that bond also indicated that the defendant was not to have a firearm. And here we see him with a firearm. In this case, Your Honor, I would submit to the court that he also is a risk to the community based on the factual scenario that Your Honor has heard previously. There was an argument between Mr. Russell and Mr. Jenkins. And when I say argument, Mr. Jenkins was speaking with, it sounds like maybe a family member of Mr. McKinnon, because it was an individual who was in a wheelchair, Mr. Aldridge. At that point, Mr. Russell walked up and just began to fight physically with the victim, Mr. Jenkins. And at that point, the defendant, before Your Honor today, runs up and you can see him on video. He's got his firearm out. They step out of the video footage and then the shooting occurs. And then he and Mr. Russell then flee the incident location, Your Honor. I would submit to the court that based upon all of that, the defendant is not a good candidate for bond at this time. As Your Honor is well aware, this is a case that's been indicted, so he's not sitting in custody without an indictment. I believe he's been in custody at the time. I think it's 65 days today. So we were able to get Mr. McKinnon indicted well before the 90 days. And I believe all the circumstances warrant that Mr. McKinnon stay in the custody of the Fulton County Sheriff's Department. And we move forward with the judicial process for his case.
You started your comments by saying that you believe Mr. McKinnon posed a flight risk, and then mentioned that there were warrants taken out in November of 2021. I missed the connection of those dots, or maybe there was more info that you were going to share. What's the, there were warrants taken out because the investigators concluded they had probable cause to arrest him, maybe because of video footage or identification someone made. What's the flight risk part of that?
So I apologize, Your Honor. My brain went straight to the Cobb County cases. I would submit the flight risk is that at the time the warrants were taken, the defendant was well aware that the warrants were executed and outstanding for the defendant. He was not arrested until March by the fugitive unit here in Fulton County. So roughly, 5 months later. But it's my indication, it's my understanding when speaking with a detective who indicated that he actually had an opportunity. He reached out to the defendant, letting him know over the phone that there were warrants, and then there was no communication after that.
Got it. Okay. Thank you for sharing that.
Yes, Judge. He is indicted on both cases in Cobb County. One is before Judge Ingram and the other is before Judge Childs.
Okay. So the Cobb cases have now been indicted.
Yes, Your Honor.
And there's a failure to appear somewhere out there in connection with at least one of the Cobb cases.
Yes. And I didn't mention that because I believe the failure to appear is related to the fact that he's been in custody here,
okay,
which would moot it or negate that he had any failures.
Got it. Okay. And anything from Mr. Jenkins's family? I think I've heard from them before. I'm happy to hear again. That's really up to you, Ms. Rolak, whatever the situation is.
Yes. Miss Jenkins, the grandmother is on the Zoom. I know Your Honor has heard from her prior. She may want to reiterate today about her opposition to bond for this co-defendant, Mr. McKinnon.
Sure. Ms. Jenkins, what are you the iPhone?
Yes.
Okay, I've got you. You're on the screen now. Good morning again.
Good morning.
Anything you want to add beyond what Mr. Abate just shared or what you've shared with me in the past?
No, other than, yes, you do remember me sharing with you in the past how much this has taken effect on me, losing my grandson at an early age of 28 years old. It's hard for me still to contend with, and I do oppose this person getting a bond at this time. I'm sorry, but that's the way I feel about it now.
You don't need to apologize. I think everyone could understand why Mr. McKinnon's family wants to get him out to be with his infant son. I think everyone should equally understand why you, still grieving over the loss of your grandson, would not want Mr. McKinnon out. So no apologies needed.
Thank you.
I appreciate you staying involved with this. You've got a right to stay involved, and the district attorney's office will continue to update you whenever there are other appearances by either Mr. McKinnon or by Mr. Russell. Okay?
Thank you, Judge. Thank you.
You're welcome. Thanks for being here. All right, Mr. Lassiter, anything you want to share in closing in connection with your motion for bond for Mr. McKinnon?
First of all, Your Honor, I'd like to state on behalf of the family that our presence here today requesting bond in no way reflects our appreciation and understanding of her grief and concern for her grandson. Secondly, Your Honor, Mr. McKinnon does have charges in another county. They do not reflect that he failed to appear because of his own irresponsibility. We also would like to point out that, you know, an officer telling you having a warrant and you having official notice that you have a warrant and failing to appear does not mean you are a threat to leave the jurisdiction or threat to fail to appear when required by the court. None of those things, in my opinion, should disqualify Mr. McKinnon for bond. He is present, willing to stand forth. We also have issues with exactly how this matter occurred, and I'm sure that everybody involved would want to know exactly how this matter occurred. We ourselves definitely want to put forth and find out all of the evidence to support what we think occurred, what we will be willing to tell the court that occurred. And we just want to be able to have Mr. McKinnon get out so that he can help us prepare an honorable defense to these charges.
Got it. I appreciate that, Mr. Lassiter, both your expressions of sympathy for Ms. Jenkins and the Jenkins family, but also your observation that right now, Mr. McKinnon, of course, is presumed innocent of these charges. They're serious charges, and it's time for a defense to come together. Mr. McKinnon, are you able to hear me?
Yes, sir.
Great. Let me get you back on the screen as well. There you are. Okay. Mr. McKinnon, at this time, I am not going to set bond in your case. I'm going to explain why, but I'm also going to explain to you and Mr. Lassiter what you ought to do if this case lingers for any reason. What I've got in front of me is that in July, you got arrested in Cobb County with drugs and a gun. A month later, you got arrested in Cobb County. It doesn't matter where you were arrested. You got arrested with drugs and a gun, emphasis on gun both times. Fast forward just a few days more, you're out on bond for a second time for charges, and then you get mixed up in, don't know the facts and circumstances. I've heard the state's recitation, and I know Mr. Lassiter is going to be working on your behalf to flesh out a little bit more about this case. It sounds like the evidence will show you were around, and what a fact finder, a jury, or if it's a bench trial, what I would need to do is figure out what exactly was the interplay between you and Mr. Jenkins and Mr. Russell. But again, there's a gun. I'm not comfortable that at this time, despite your sister's best wishes and your family's best wishes, they could keep you out of trouble and keep other folks out of your way with whatever kind of business you might be mixed up in. There was too much going on in the summer of 21 for me to say, let's try again until we get a little more clarity about this case. So for now, I am not setting a bond. However, Mr. Lassiter, if there are delays, number one, in you getting discovery, or two, in us moving this case along, if you file a motion to suppress after you get the discovery and the detective can't make the hearing, or things are happening that are slowing this case down that are not you saying, no, I need a little bit more time to work with an expert. If there are things that are slowing the case down, I need you, and I know you will, to raise your hand again, file another motion for reconsideration to say, you know what, Judge, it's been X weeks and nothing has gone on with this case. And it's time to think again about whether Mr. McKinnon ought to get a bond. I appreciate very much the family support he has, and I'm not discounting that, but it is, Mr. McKinnon's a grown man, and it is not his sister's job, his mom's job, or the mother of his child's job to keep him out of trouble. And though they may love him a bunch, what I'm seeing in the summer of last year is that Mr. McKinnon was not doing a real good job of keeping himself out of trouble. And he's the one who needs to own up to that. So I am not basing my decision on the FTA out of Cobb. I appreciate Mr. Abate's candor that from his read of the record, the FTA, the failure to appear, was driven by Mr. McKinnon's presence here in our county jail. So we're going to leave it as is. I'm going to ask Mr. Abate to get to you, Mr. Lassiter, as soon as he can, the discovery in this case. Some of it may come electronically. So if you get a link and are having trouble downloading evidence, please reach out to Mr. Abate and his support team. What I don't want us to do is have to get together for another discussion about bond. And the issue was, I couldn't get the evidence.com link to work. That's something that the lawyers need to work through. And I shouldn't get dragged into that unless the state is refusing to help out. And in my experience, that's not what they do if a lawyer says, I need some help with that. All right.
If I may, Your Honor, I'm pretty good with electronics. I'll be glad to work with the state on getting to discovery. I'm not a stickler for speedy trial motions, but I would like for this case to move along as expeditiously as possible. And
Good.
I assure you that this attorney will not be the one to hold us up.
Well, that's good news. We have a number of cases where there's been some turnover in defense counsel on the appointed side, and it's great to have someone saying, I'll be ready when you say ready, Judge. So we will move Mr. McKinnon's case forward with all deliberate speed, bring to my attention any delays that come up, and we'll go from there. Mr. Abate, anything else in Mr. McKinnon's case?
No, other than I assume counsel is going to file his opt-in discovery. I was looking at the record. I don't see it, but I'll get it.
I couldn't understand Mr. Abate, Your Honor.
Sorry.
He had muted, but you'll be able to hear him now.
I'm assuming you're going to file an official notice saying that you're opting into the discovery under 1716-2.
I can. I stated in my place earlier, but I'll be more than happy to file one.
If you would, Mr. Lassiter, that'll be helpful. Just because, as you know well, there is at time movement amongst the prosecutors, and they rely on the docket rather than maybe a notation in the file. So you filing that, I think, will dislodge more discovery from the state sooner.
It'll happen will happen before the end of the business day. Mr. Abate, could you yell out your email?
I have yours. I'll send you one, sir.
Thank you very much.
All right, Mr. Lassiter, anything else on behalf of Mr. McKinnon?
Can't think of it right now, Your Honor.
All right, we'll reach out to Ms. Nelson on my team if you need something from us. Otherwise, I'll enter a scheduling order. Hold on one second. That'll have a deadline for the state to get you discovery, and then a deadline for you to file any evidentiary motions. If there's a motion to suppress a statement or something that was seized, not motions in limine, but something where we need a hearing. And that'll keep the case moving along, all right?
Thank you, Your Honor. May I be excused?
Hold on one second. There was a family member who had, I think it was Mr. McKinnon's mother, not sister. Yes, ma'am.
Yes, I have letters got from our school, from the company, from the church, and stuff like that to give you.
Okay, do you have them with you? Okay, I'll get those from you before we break for the day. Mr. Lassiter, if you would file two things today, and it can be all in one document, that opting into discovery, but also if you would file a waiver of arraignment. We've got a form we use, which we could send you, but you're welcome to create your own. I think Ms. Nelson may have just sent you our form, but if you would e-file that, that'll be the official waiver of arraignment, and that'll trigger the scheduling order that we'll get out.
Okay, I have a form, but I'll be glad to use the court's form. And
however you want to do it.
I did forget to mention that his family had letters from other people in the community, and I'd ask that they be entered into his file.
We'll definitely do that. We'll make it on this record. Mr. McKinnon? You're just waving to family?
Yes, sir, my bad. What you said?
You had raised your hand. I just wondered if you had a question.
Oh, no, I was just waving at my nephew and my son. And I was just wondering, what do I have a next court date?
Mr. Lassiter will talk to you about that. He's going to get discovery in your case and meet with you so you can see what kind of evidence the state has or doesn't have. And you and he will then start figuring out what the right next move is in your case, okay?
Yeah, and I just want to let you know that I'm not a bad person either. That what happened, that ain't had nothing to do with me.
Okay, well, I don't want you to talk more about your case. That's for Mr. Lassiter to do, and we'll get you in court for that situation, okay?
So I'm not gonna come up for another bond?
You may. That's, again, you and Mr. Lassiter will talk about that, but not for today, all right?
You gonna take a long time?
I'm gonna have Mr. Lassiter talk to you about what a long time. I'm ready to go, but your lawyer needs to get discovery and he needs to talk to you about that. So he'll be out to see you soon to work through that discovery, okay?
As soon as I get it.
All right. That's it. Captain Betts, thank you for your help today. Sorry for the delay.
No problem, Judge. Thank you.
You bet. Thank you, Mr. Lassiter, for your patience.
Thank you, Your Honor.
You're free to go.
Thank you.
I'll be back at 1.
Yes, thank you. And again, sorry for this morning's surprise.
You can step out of the booth, Mr. McKinnon.
Yeah, and I think, Captain, that's it. That covered our calendar with that little hiccup. So I appreciate that. I'll have all the booths drop. We don't have booths in the afternoon, right? No, so we're good. All right, so we then will be in recess till 1 o'clock. Till 1 o'clock. All right.
I don't remember something given to you. Or is that something?
Probably to Ms. Rivers. I think that's the cleanest, and it can just be part of the transcript. Thank you. Thank you for these.
Thank you. Okay. So, I'm gonna get all the files out. Okay. 2 people. Do you know if the 130 people are here too, or just the? Okay, that's fine. I'm gonna just sit.
Yeah.
them out.
Let's look. So we could do that first if that helps. We've got 2 calendars this afternoon. You see where the female is. Who is that? Is that Linda Harris?
Yeah.
Are you handling Linda Harris's case?
I think so, Josh. Is she here?
Yeah, everyone on the revocation calendar ought to be here because they're in custody.
I'll handle her.
So then the question, what Deputy Gordon was asking is, when would we do her because of, 1 second, ma'am, because of space questions back there. My thought was we'd just do that first.
That's fine.
Even though it's at 1:30, you'll be here at 1 anyway. And so we could do, does that help you to do it first or does it help you to do it last? Last.
Okay.
We'll do it last.
That's fine.
Great. You have more time to prepare.
Thank you.
Okay, last it is. All right. Yes, ma'am. Of these letters? Sure. It's going to take a minute, but. Oh, you want to take a picture of them? Great. You get that faster.
Okay. And we'll see all these people on one court calendar, and then we'll see 1:30 when they get here. We're ready, ready to start. Let's see while it's here.
Excuse me,
Yes, ma'am.
how do, my son is supposed to handle the cases in Cobb County?
He won't need to because he's here. I mean, Cobb will learn why Mr. McKinnon can't go to Cobb. And usually what happens if someone has a more serious charge in one place, the other place says, we're just going to wait and let the more serious charge get resolved. But sometimes we'll loan someone out. And so if just to keep it simple, if Mr. Lassiter was representing your son on the Cobb cases, he might ask Ms. Nelson to say, could the Fulton County Jail loan Mr. McKinnon out to Cobb so he could go resolve those cases and then come back here? But usually, and Mr. Lassiter can advise you on this, a defense attorney would say, don't worry about those. The serious charge is the one here in Fulton. Let's stay focused on that. Cobb will just be on hold until the Fulton charge is worked out. All right, so I'll be back at 1, and our calendars that everyone did get will mow through.
Then you wanna go take a nap, take a nap?
Yeah. Oh, okay, yeah, I want to bother you too. And really too much going on. But, girl, you still over here? Call me, just call me, and then if you want to call me.
I said, we're gonna take a nap.
So you don't need, you can post it on night and, just, That's a non-penal. Right. Shane went down, but I'm just gonna put my hand. Oh, damn, I don't know, I'm wrong. People. Thank you. Get that deal. They must be like it. Oh, yeah, that's what I'm putting in. To that, this I mean, you don't say no. No, I know what's up. It's not trial, it's a courtroom. I don't have to put nobody in this, you know, later, if y'all went down, they just. Yeah, they are trial. It's not a reason, I'm just, you know, yeah, they, you know what I'm saying? Yeah. Yeah. And it's not like, you don't get who all time, it's yeah. No, we don't be this place. Yeah, I'm trying. What's up, man? Oh, down there, you up there? You stand like that? No. Yeah, if you're not saying like, I don't know. I don't know what she's saying. I know she just got 1-8 in 3 o'clock. But I don't know, I gotta look at it. You on now? Okay, I think. Is Charles on that too? Yeah. Okay. Okay. Hi, good morning, I'm walking out of court now. Going downstairs. Yeah, it's like. Thompson, you didn't know that you gonna work with them. Yeah, you're gonna do it in the morning. And exit. I'm not participating. It's just make it.
I was at child.
Are you gonna work with child or them? You work with them? You work with her? Please stop.
I know real, she said, no, somebody had something, she did.
So that did happen.
No,
Somebody did
that
happen.
but she had already tried to do it.
How you know?
Call the nurse, come on, man.
Yeah.
So they posted that video. Well,
That's the whole
So how it works is, and this is my understanding of it, they try to convince you to do stuff, you do the video, we actually kind of like believe in them. And then once you, after you already don't, they don't stuff you in with it, and they have to pay and then post that video as if you. Yeah, I mean, it is.
So that's not a fair.
It is a
That's a
pay,
fair.
they have to pay. Yes. It's court, okay, it's 2E back up, it's still up? Okay, you just gonna escort her car? Okay, you need some assistance with that or no? Okay, okay. Hello? Okay, y'all do it then. Miss Wayne, yeah, he real cool. Okay, well, this should be straight then. Yeah. Okay, Counsel gonna be working with you. Go to the checkpoint then. Just call it out the checkpoint. That you go to. And she said they don't want nobody over there, even though they don't have an appointment. Oh, okay. All right, then. Yeah, you go to the checkpoint. She says, a plea at AC. Not most definitely not. You heard me? She says a plea. No. I ain't even get it, she gonna send me, and then she said, who you got? You say Grace?
That's Steve.
What?
Just say hi, damn. Shit, crazy.
Hey, so we, go back now, and talk.
Yeah.
So,
I don't know what they say.
how about
Yeah, this, I guess this is what I'm doing. Yeah, somebody they need somebody. So they don't say they don't got a plea. Yeah, I'm not done. But she cool. Oh, well, yeah, y'all not done right now, so. I mean, if y'all come back up at one, you can have one check on you. I mean, y'all take the money, y'all come back. That's also, I will put you in, but that's what they said. 3:00. Look, you better take me home. Cause I'm talking to you. I was talking to you. I don't know, that, y'all know about mission. Lord, it's the worst, it's like he gave me words, words like, I'm proud of that. Next time I read women, or I knew I shouldn't have been here. No, we're gonna beg for it. If you don't know anything about it, that's why y'all need honor. It's good. But, I can feel some. But it can get worse. I mean, y'all have no idea, like, it's just, and it seems like it got worse since I had my last baby, like I had an epidural. My back was hurt for a week. It was hurt for a week. It started with. Then I left my parents in the car. And they tell you all that shit. You went pain, but you went pain, but then they tell you that you're shot with, you know, and get paralyzed. So you don't even know what to say to you, like, get to me, but no, don't push me.
He said we gotta take him back down to take lunch.
Y'all got
She wants to be 1:30. Oh yeah, whenever 1:30 people get here, I'll talk to me. If that's cool with you guys.
The mail's cool.
Or any of them, yeah. I'm just trying to get us out here quick today.
So you ain't talking about that?
No, I just talked on the 1 o'clock.
What 1:30 people at?
This is downstairs, remember?
Oh, we go get them.
That'd be great. Yeah, I'd love to talk to them. Oh,
yeah, so I think some people,
Your space was given to me.
okay,
We can take that one down.
Yeah, we take that one down.
So every time I say.
so I'm gonna go ahead and take y'all lunch, I'm gonna start calling. Yeah, who y'all got to go down?
This one.
Okay, who's it, her?
Latrell Russell.
Russell, that's it, who y'all need to come up with?
Everybody else is doctors.
Okay, I'm still down.
You got money, you got
Yeah,
money.
yeah, I don't know, I mean, it's supposed to be friends, so.
Yeah. Every time I've seen her in jail.
Yeah, I'm taking y'all lunch.
I don't want to talk to you. Okay.
Let me tell them, come here real quick.
Just leave it like it's
Yeah, and.
What did you say?
Correct. Yeah.
Take one down.
And then come back, just come back and like.
Yeah, we'll just wait.
Yeah.
So that's why that talks more.
Okay, you just reach out.
Let's see, so everything else, I'll talk to the prosecutor about this one, but, I mean, if something happens, not a huge joke, it's just a side calendar.
Y'all got, how much room y'all got, y'all got enough for everybody?
Okay, so they should be here, this one is, zoning.
So this is coming up.
That was, I was really so this shouldn't take long, and then there's probation. Okay.
And one female and a male.
Okay, and hopefully we'll be able to move. Okay.
Four females, four males and one female.
That's
one
one down.
1/3 of the want them up, and then one person got.
There's a, so
Okay.
the jury room is usually open. Okay. So yeah, okay, it's like coming out right there. Yeah.
Okay. I know he ain't on lunch already. 13, 16, raising 13, 18. 18, 5, 8, 8 else for 18.
We're gonna go to the jury room, but whenever the 1:30 people get here, just let me know, and I'll pop back there.
What's your name?
Lacey.
Oh.
And this is my intern, Retta.
Oh, yeah.
Hi.
Hello. What time is, oh, you can go get, what's her name? wheelchair. She in 2A. Go see if she need a lunch break, because she started at 11. So she may need a lunch break. But I'm just call it, and then I call it over the radio. If you go get her 2-618. Okay. Okay.
It's not it.
Counsel, now, he won't be asking no questions, why you can't assist or whatever.
Status. All these statuses.
Counsel.
People, you can. Yeah.
Now, go ahead, they're gonna be standing by. They'll down, and then the 4 males and 1 female. Okay? 4 males, 1 female. And then they want to talk to people. They can stand by, that's all they bring out.
1-7. So, you know,
Yeah, both of you on something. Not the man, I always tell the ladies on, they be calling that on. They're not fun to. Yeah, I mean, I don't know, what was that, a dirt bike? It was like a. It's my, it's working in college. She said it's 5'9". Yes. If I was telling you, how you gonna ask now, what you gonna be asking, why you can't go work? Yeah.
I don't do all the microwave.
But they be under the pressure, like we training, y'all supposed to train the people, y'all need to be doing. So y'all got.
You gonna bring it to me? Huh? Gonna bring it to me? Yeah. Bring the place, so I can bust it down. I got a bowl enough. I got a bowl too.
I'm just stop working out there. I mean, I ain't working out, no, every time I stop. I just start eating right and stuff. And we do this on the move, I ain't been doing nothing. If ain't wrong with you, or you know, you have a lunch.
No, he got 10. Yeah.
Okay, I guess we'll just go, they got one, but they taking a lunch. So they're on lunch, and we're gonna go down and drop their one gun and bring the rest of them up for 1 o'clock. I thought that your trainee was with you, and then y'all.
We want to, she had been doing something, and she got me doing.
What you got you doing?
I had to fill out, performance appraisal.
Okay, you can just go ahead and do what you doing then. You should just send it.
Oh, you know it's foul now. You know it's foul. It's not foul. Yeah. So we got the one, and then you got 4 bills.
Okay.
Take one down.
Take 1 million down.
Yeah. 2.
But if you really get occupied somebody else, you can do it. It's other people, but the reason why I called you is you had training. Yeah, how was he? He's pretty good, right?
Yeah, he's getting trained right there.
He was with me last week, but he already know.
Let's go be like that, son.
Yes, he is pretty good.
He was with me last week.
He was. He'll tell you, you heard him, he said he was with 13, 16, he really still thought that he was with me. Like, you heard him, yeah.
What's your number?
18.
Yeah, you stand up like that, son? I'm just.
He did good.
I know why he was 16.
I
Oh, yes, I do. Yes, I do.
Whatever.
Yeah.
Okay, I'll get child, let me get child family, child. You can go ahead, sorry.
What ground on it?
What do you?
Yeah.
What was that? What did he say? He didn't say a recess time.
Who's that?
Must be Riley.
This is bad. It's nice.
What? I'm not a child for me. Oh, I didn't hear her. What time she gonna want one? You gonna come back and get her one? Okay, so now what you gonna do, take yours then, and that's what you gonna do? I mean, you just give her a 2 on there. Yeah. To the checkpoint, and you just give her, yeah, whenever she, you remember what time you called to the I didn't hear you, I must be talking to you. I can call command if you don't remember. At 11:39, okay, I'll put it down. All right, thank you, Nate. Hello. Ms. Gilbert, it's Sergeant Wiley. You need lunch relief over there? Okay, okay, no problem. $13.16, raising $13.59. Are you available? You on lunch? At 1:30, right? Oh, okay, I need your help with something. Okay. Yeah. At 1:30, I just need your help with bringing somebody up from detention. I didn't let you go to lunch. I sent you to the checkpoint. That's you. Bachelor's. Okay. Yeah. What are you at? You on lunch? Are you on lunch? Don't go there. Go to, they can be their own people. See if Hope need a lunch. Yeah, cause he in court, you not one of them, what was down there? What told you to do that? Tell her, that you gotta go release, see if, Hope need a lunch. If he don't, then you can do that, but no. She can go back. Okay. I don't know, I don't have his number to call him. Yeah, I'm sorry, I didn't have his number to call him to see if he did. Yeah, yeah, see if he need or send me his number one, because I was gonna walk over, but I'm about to take these inmates down to AD. But yeah, I don't have his number to call him. Okay, yeah, just text him and see. Thank you. All right. What? Yes, I am not taking people down. Somebody had called me. Don't rush me, cause I don't leave them, I don't leave them up here and wait till y'all leave. I don't leave them up here. I'm about to call Sergeant Lee over here to help me. He's my, he training. Oh, okay, he wasn't good. $16 $5 $5 $5 8 Delta for 18 assistance. You're gonna say, they at lunch, so they got a calendar at 1 o'clock, so we gonna bring some, take somebody down, bring some new people. Hello? I'm trying to reach, this, the C7L, so they ain't called me, but I'm sure they need a lunch over there. If she got somebody else, they got all these people down there, she can't give them lunch. Huh? Yeah, they need a lunch. Green.
Like little boy, like
Yeah. Okay then. Yeah.
Yeah, I think you're getting too much. I think you're getting too much onto what she said. I think she- It's got a little bit. That's an hour. We'll figure it out. Yeah, well, obviously, yes, it's-
Oh, yes, okay. So
Yes.
I did have a question. What is a bench warrant and how is that different than just a regular warrant?
Oh, good. That's a good question. So the judge can issue a warrant for someone's arrest and they don't show up to court.
Okay.
So it works the same as a regular arrest warrant. Which ones? So it's helpful that I can like, okay, so this person, what Judge McBurney usually does is he will like double check. So do you have access to Odyssey?
Yeah.
Okay. So, which you can probably work Odyssey better than I can, but I'm gonna like show you. There's like a cool way to like see if you can do it on this one. So you can like look on here and see, so she doesn't have anything active. But like sometimes if a client has warrants even from other jurisdictions, they
show up.
Most of the time they usually do. And then also, so like he has these 2 warrants from these other counties. So it should be in here too. We don't need to go to the jail. We have to do it.
We can, we just have to get our jail IDs, which supposedly is a bit of a process.
Okay.
So we should have them. Jennifer said she wouldn't promise a time, but she said by next week.
That's fine. I was just curious.
Yeah.
Okay, so like this one right here. Oh, that's a hit confirmation. This is showing that he has, this is like their like jibber jabber, like for like between radios.
Yeah.
To show that he does have an active warrant. So
Okay.
right there, it says confirm. So like which you might already know this. So like if I'm like telling you something you've already been told, just be like, I already know that. So yeah, so that's why he has 2 holds from those other counties who's got active warrants from those jurisdictions.
Okay, that makes sense.
So like there was one that I'm gonna show you. Oh, it was like from the morning calendar. What should I do in the calendar? So this guy, so he was actually a bench warrant. Oh, back in the day. So I'll show you what it shows you guys. So it'll show up right here, and it shows that it's closed out when they're arrested.
Okay.
Should be able to see a copy. Okay, let's get on there. Tricky jailing, I'm just curious at this point. Yeah, so like right here, that's what it would actually look like.
Okay.
Just showing that he missed court back in 2020. And so basically, yeah.
Okay, that makes sense. Okay. I mean, that's what I'm thinking.
Yeah,
But
that's a good question.
Yeah. Oh, yeah, if there's, because you guys were talking about how there were like conflicts with various people. When that happens, obviously, like the PD office can't represent them, but do we like, who, like, does it have to be a private attorney or is there someone else they can go to?
Good question.
Yeah.
So we have the Metro Conflict Defenders Office
Okay.
here. So it's like confusing because like, sometimes I can look at the calendar and tell you like just by the name of the attorney if it's a conflict case. So like this one right here, that's a conflict.
Okay. Oh, I've seen their names.
However, it gets a little confusing because so if there's like multiple, then it has to be what's called a C3. So like, let's see. So that would be a private attorney who takes cases.
Okay. Because I knew there had to be like some, like they can't just say, okay, you don't get an attorney because.
So she's a private attorney, but there's been such a short, and you've probably heard Judge McBurney allude to it, there's been such a shortage of conflict C3 attorneys. So she's like normally just a private attorney, but she's like stepped up and said, hey, I'll take on more cases just to help. So that, yes, that was a really good question. Yeah, so that's kind of.
Okay, because I've been wondering about that for like a while, like I didn't understand how that.
So like this also is a conflict, you'll see the calendar call it 1. Okay. Go see our people.
I know.
There's a 5 out here.
I know. Okay, that makes sense.
Yeah, of course.
Thank you. Okay, I'm gonna go to the bathroom.
Okay.
There are no napkins.
I'll be here.
Yeah.
We brought the 4 guys up and female. Oh, I see that. Yes, she's done better. I'm not sure that's everybody you needed.
Yeah, that was fine.
Okay.
Appreciate it.
All right.
Show me outside of safety on Friday, okay? When you're 13.
I said, I'm gonna try some of them.
Okay, Ms. Wood, you want to speak to somebody?
Yes, all of it.
I know you. I know, that's how I'm told y'all to come over here.
What are y'all doing on that side?
I don't know.
I hear the shit, but it's a girl, you know.
He here, right? Just when I was on my list, you already out there, right? You out there in the other side.
All the time.
Okay. All right, coming back.
Who would you like to speak?
Do you have all the ones that people? I can see.
Even the female.
Great. Which one is it, does it matter which order I see them in? Okay, let me see Mario Copeland
Mario Copeland. Mario Copeland. Mario.
So.
Okay, so you have the new case, I don't know what they do with that case, I have a probation verification.
Right.
So are you interested in resolving it together, you want to have a little about together? What's
I wanted to take everything taken care of today.
The new case is the Dollar Tree, right?
Right.
Like you deodorant. Was it really that many cases? They said that there was 200 packages of deodorant. Okay. Okay, that's just check.
That was my 6 out of 9. I mean, I've been in this in July, next January 24th. But this is my thing. Besides the probation thing, right?
Right, so that's the main thing we're here to talk about is probation.
Yeah, I got out of prison in 2020, right? I maxed out on 5 years since 2020.
You go down the road with the special. Do you have a special problem? Have you ever driven down the road? Oh, have you ever done drug work?
Yeah.
Are y'all on lunch or anything?
When did you drug?
Long time ago, like 2012, 2010.
Did you?
Okay, is he still busy or whatever? Okay, because they, I know you and the 4B are in need of
And
27.
that had something to do with prison in 2015.
Yeah.
So, the only reason I asked is just for.
Okay. Okay, thank you.
So I know this is a case of either way.
Look, see, you did, you can have maybe like.
This is why I see. Which
St. Jude's. St. Jude's.
Did you complete that one?
We got one, but it's.
I'm only asking.
So you trying to put.
Yeah, I
You
did.
trying to have it sent to them?
2007.
I'm trying to, yeah. I know it's gonna be.
Hello.
Yes.
So the reason I asked.
Yes, basically.
Because I'm not sorry, office today, it's just a matter of what judgment you don't have time to have left on your cases. See, this is, so how much time, do you know how much time you have?
You
Yeah,
own
I'm gonna tell you, this book has started in 2020.
I don't think, yeah, it is one.
I had a taste, I served probation.
Okay, this right here. Okay.
I never went to see them, but they told me not to be anywhere or so I did have COVID. I was really sick with COVID. That's why I let me go like.
Yeah, because they'll say they are when they.
Well, that's why-
So this is for the.
Yeah, I do remember feeling this part, but I'm sure I probably did. Yeah, I know they put this.
That's the
That's
You're not.
You
I
guess
don't
which
know
one?
if you're free to just.
That's what she said.
She said she wants to write every day.
If you want to ask the judge, your case.
She first come and said 1 and 2.
Thank you, cool. No, man, it says records accessible, and you have to complete steps in one. No, they, you already doing it, but it's out.
So she doesn't agree that.
I would just put the FMLA that you already got it right here, and he's on
That's
there.
valid probation.
And you don't energy and stuff on down there.
Okay, well, I'm gonna read
Yeah, and just put the FMLA, I mean, I don't really remember, yeah, I just if they think, FMLA, don't have it, whatever, the lady ain't gonna tell me that. Hang on.
Correct.
I just want to.
They don't need that much help.
Non-negotiated, like.
What you mean?
Judge ask.
You gotta,
You
okay, I'll give him a call, cause you gotta go, cause you the second, you the,
So.
okay, I'll go back. I'll give him a call, okay.
Right, so resolve probation.
Or they really take probation, not get out of though, like, they really, they not like, go see them.
Right.
Well, no, who got the case? She needs to reach out to the I know that's on somebody's consent, so she probably could reach out back to them to let them know that, you know, she did what she did, and she's trying to file consent. Maybe she filed contempt and. That's what she wanted, and what they said, because I guess once she filed it, it's gonna go back to whoever got the case, which is, she just.
That's
For the child. Because it wasn't, what else we do? Because
That's what I'm saying, so it's gonna go back to, she originally had the case.
Yeah, Granby.
So the consent gonna go back to them.
Well, I know, a lot of shopping did like, I got my friend that did it.
Just file it in the clerk's office, and they gonna, it should go back to them, or they gonna assign it to somebody. No, but she did.
Family something, family law.
Yeah. I'm second for that.
So let me answer the next question.
She said it's on the film, what that paper say today? Oh, that's on that paper. Still out there.
All right.
That's one.
There's no one else, right? Family law.
Everybody is.
Family something.
And my, I say first, I take all of them. And then I have my kid's mother, which is 2280.
Yeah.
Actually, I'm sorry.
What do you think? You feel you shouldn't get paperwork back?
How many kids you got?
Two.
How old are they?
14.
Yeah, you need to get the paperwork too.
Wow.
The thing is, they is get them up there.
And how old are you, Mr. Griffin?
49.
Palmer, you good?
They're gonna make her come for the name of it, he gonna be here until
When
4.
I graduated.
Okay.
You're there for college. And for the term of it.
There's so much to say.
Well, I just like a right. I was torn between two places because my first mistake was not going out of Georgia, away from home, instead of staying in the neighborhood where I grew up there. But I had to like, I like stay close.
Oh, this thing that I had to say, you want to prescribe something, say, here. Yeah.
And I can't be much.
We don't went, we took, me and Hope took some down,
Last time.
just a lot of them. But Gordon, I don't know, he's supposed to be eating, but, you know, he keep popping his head.
He's waiting to get out soon. He owns a detail shop. on, well, it was on Headland Drive, now it's on the low drive, that's probably where I live. He has a new business there. He wants to work with. That's what work with. Before I already all fixed business, so we were like, just like doing both, kind of get, out there, yeah. That's what I'm trying to do. That's what something old, maybe.
So we'll look through, we might be called you out, we will let them know.
Like we there.
And address the probation revocation. And then we, y'all do it. And then, we'll ask for the revocation on the reinstatement probation. Be advised, they will vote that.
You want to speak with anyone?
I can speak to Ramel.
Oh,
Mr. Williams.
Williams. Ramel. Yeah, she comes.
Okay, I'm back.
Okay. Child.
Oh, she gonna be able with us?
Yes, child. Yeah, that's up. Yeah, we could, they just came in. Just, yeah. She gonna be up here. We gonna be up here. Wednesday night. Oh, really? Which one? No, no, we. Oh, yeah, that's what, okay, okay, somebody, okay, did in the bedroom. Who was that? That was just so low. Did you catch it? That was so low. Oh, that's, Lord. Okay. We just got, the ones from. We volunteer around service yard. I was scanning here and seeing an additional unit with me.
When he called it?
Yeah, the guy, whoever it was out there, said he had additional unit, but you want us to still provide assistance. It's like, you could just went out there as a supervisor to see what's going on and stuff. Everything good. That I was just, we just brought 4 people, coordinators and everybody, pretty much everybody shared the lunch. So I sent, they might want to get a guys one in the 7th. And then they're gonna be deliberating in the 2nd.
Okay. You got a cost for them fee or where?
He went to give them a lunchroom and his room inside for B.
And that's include her and her friend?
She dealing with the issue with her gun, their gun is stuck inside the 5C in the gun locker. So they've been in there, they done, but they dealing with their gun. No, they don't took all their people down, but they gun, and she called me and said they was done, and they gun. I was like, well, Lord, I didn't get the master key. And she was calling me, I'm like, okay, I don't think I can tell you, but I didn't get a master key. Let's get it, or you can contact Butterfield, he's the one that worked with the gun lockers or whatever. But apparently, Kevin come out the lock. Okay, it's beyond me, I can't, yeah. That's it. Everything else is, yeah.
You have nothing coming up late?
Besides, AC and Thompson and Dunn going in there at 3 o'clock. It's a lot.
Okay.
I'm telling you, 2 tanks full and it's a female back there.
Okay.
Yeah, so it's just, I think they had, yeah, they probably got 14 since we only dropped 1 down. Since everybody is there, because they had them all. But it seems that I'm gonna see it, the jail. Like 8 and 10.
I'm just wondering why it's.
Yeah. I only know because I see her on the camera. I actually want to do my own. But she has no position.
Oh, okay.
Carlton, you gonna assist over here? You already been to lunch?
I need to go lunch.
Huh?
Need to go lunch.
Yeah, because you're going to AC with Donnie 3, remember?
Hello.
Yeah. Hi. Yeah.
3 o'clock.
I want to double check. You gonna double check? Yeah. So, because she was like, she went down, and she asked her, and she was like, to be moved, and she said she went outside to see what was going on. And I didn't even get a chance to get out of the hall. I said, good, yeah. But they came on, I was just trying to see.
What's up, child? How are you?
I don't know what that is. Problem. I don't know. Is there no, he on the late list, so he couldn't, he said he was just formally me. He on Thompson here and Charles done. So I'm saying now.
What's a lot of them all there?
Oh, yeah. No. You already sure. That's last time. Call me if you need assistance. I think she's. I'm gonna check, but I don't have. No, I don't have. Engagement time. I know. You guys have any pleas? Oh. You guys have any pleas? Potentially. I know. You always say.
hard. It's not my decision. Yes. So she's back. Thank you. This is oh yeah, I think the rest is mine. Yeah. What? Simmons? Oh, she is here. I haven't talked to her yet. Okay. Miss how are you? Well, hanging in there. How are you? Yes. Well, I'm sorry, I'm strategic. It's the job I did, but I searched it on the internet. Oh, cool. All right. So it's not through, but it's like a video and everything. That's fine. I'll get to it. That's totally fine. I was just trying, because I didn't know if I still had access, if I could like find it since it was someone that doesn't work with us anymore. Yeah. But thank you. Appreciate it. I'm sorry about that. No, you're fine. So, oh, sorry, Lee. I just saw your text message. Who let you in? Oh, sorry. I'm really sure. However, okay. So like, this
Welcome, may I see it?
Got a lot of deputies. 4. I know what we're doing this afternoon. It is a lot of movement, and we know you need backup. All right, good afternoon, familiar faces who were here earlier today. Good afternoon to folks who are just joining us. Let's make sure Zoom is up and running. It is. Hey, Ms. Patterson's on this call. You can't work out Mr. whatever case that was, Horton? A little too late? Okay. All right. If only we could have worked out Ricky Wolf's case. It is. And now he's going to eat the murder here. And a co-defendant. All right. We have a series of status conferences starting at 1. When we get through those, we will turn to the revocation hearings, and the deputies have asked that we try to handle Ms. Harris last, just for inmate movement back in lockup. So if anyone is here for Linda Harris, we're going to do it, but that's going to be late in the afternoon. All right. So our first position is Mr. Toray. Is he here? Don't bring him out quite yet. I just want to know if he was here. I want to get an update from the lawyers. I've got the report from DBHDD indicating Mr. Toray is in a much better space, or he was when he was at DBHDD. He, of course, has made the transition back to Rice Street. And so I guess first, who's handling his case? Ms. Wood, Ms. Feely? Great. Did you get a chance to read the pretty lengthy report from DBHDD? They did their homework.
I have reviewed that, and as the board, I think knows, Mr. Toray does require a Spanish interpreter.
That was the next thing I was going to ask. It says that here, so I'm sure we made the request, so we may need to hold off while we wait for Mr. Laris or one of his colleagues.
I was hoping to have a better update from the court, but we are working on getting him set up to be transitioned to the outside, and that's what Ms. Patterson is doing us.
Okay. So Mr. Toray, and when we get an interpreter here, we can discuss this in his presence. He had been off dockets while he was being restored. He's been restored. So when you say you and Ms. Patterson are working towards something, that would be a negotiated resolution with the state, or because he hasn't been civilly committed, it's not like we're working through a civil commitment situation.
Right, I don't think he needs criteria or something.
He does not.
So yes, we are hoping to be able to work something out. Obviously, this is an old case, so it's a priority. I think the incident date was November 2015, but we don't want to just not have a plan in place.
Nope, no, a plan is a great thing. When we get an interpreter here, we'll get Mr. Toray out. You can provide that update. Have you been able to interact with him at all yet?
Met with him with an interpreter at this point.
Okay. Well, we will figure out how to make that happen. Do you have one on your team, or does that require a court interpreter to join you?
My understanding is we have an investigator. I don't believe that court certified interpreter, but somebody that are.
For your purposes, you'd be able to connect and communicate with Mr. Toray.
Yes, sir.
Okay. All right. We'll hold for the interpreter on that. How about Wallace Myron?
That's fine, Judge. He's in custody.
Should we bring him on out?
We can, who's handling this? Okay, the only reason we can bring him out, Judge, he wanted to see if we could negotiate today, but I wasn't sure who would actually be handling that.
The answer is, of course we can. We just need to get the right person in the room.
Yes, Judge.
Okay. Mr. Thomas, how you doing?
Doing pretty good, sir. How about yourself?
Well, what does that really mean? Last time I saw you, you weren't feeling real good and you were starting to get a little horizontal on us because you weren't well. Are you a little better?
Yeah. So I am better. I'm just waiting for a negative test.
Excellent. Well, you stay in that quarantine room we've got you in until you get that negative test. Will you be handling Mr. Myron's case?
Wasn't aware this was DV. I can check and I can get back with the court.
I don't know either. And frankly, of course, I'm neutral as to what it was. I need a prosecutor who could speak with Ms. Wood.
I know it's not labeled as such, but I believe after reading everything, I think it is DV.
Okay. Okay. Ms. Beza did?
Yes, Ms. Beza.
Okay. She kept some of her cases. I don't know that this is one of them, but I bet Ms. Patel can help us navigate this.
So, Your Honor, if Ms. Beza kept the case, then I'll have it. So I just need to look into it. And then, is it Ms. Kyles who's a defense attorney?
Yes.
So Ms. Kyles, just give me a call on my cell phone and we can talk about it.
Okay.
Okay. So why don't we get through this? You guys can talk briefly because Mr. Thomas didn't even know it was his case. It may be that Mr. Myron doesn't get quite what he was hoping today, but if the two of you could speak first, then we'll bring Mr. Myron out. He might get a slightly better vibe as to what's going on.
Thank you, Judge.
Sure. So I will write down Mr. Thomas as counsel. Charles is quick to say, hey, you know what? He knew the victim must be DV. All right. Mr. Abate, I'm not going to bring Mr. Tolbert out. I don't know if you were copied on the email from Mr. Theory. He said he just got some discovery and saw that Mr. Tolbert gave a statement. He wants to listen to it. He's in trial in front of Judge Cox right now, and he expects there'll be a Jackson Deno hearing we'll need to have.
Yes, I did see that. He just got it. He just informed us he didn't have it last week. I believe it must have been one of the items that I guess is Mr. Whoever the previous counsel was, I guess didn't provide him that, so I have reshared all the digital media with Mr. Pierre.
Okay, so we will set it down for, so Mr. Tolbert did give a statement?
That's correct.
And it's a statement you'd want to use?
Yes, sir.
Okay, so we'll set it down for a Jackson v. Deno. That'll help Mr. Theory and Mr. Tolbert connect. We'll work with your schedule and his to figure out when we can do that. All right. Ramel Williams, is that now yours, Ms.? I think that is yours. Yeah. Right. No, I know Mr. Williams. He was sort of on again, off again with Mr. Franklin and then Ms. Patel. He seems to be for now all in with the PD's office. He may be wondering why he's on lawyer 3. Not your problem. I mean, not your fault, but it is your relationship management issue. We can bring him out if you want. I just wanted to know where we are in the process.
I've met with him at the jail at some length, and I think I do have everything. He let me know that he was visited by someone who took bugle swabs, which he had already done.
Pursuant to a search warrant.
Back in April, so I don't know if the state, where the state is with testing or what they were going to do with.
Okay, let's bring Mr. Williams out. The part of the point of these status conferences is let the defendants know we're moving the case along. If the defendant sits at that table facing that way, does that work for you? Where would you prefer the defendant to be? And we'll move one of the PDs to a different spot. They can come to the podium.
Are we on Zoom?
We are on Zoom. But I don't know that the defendant needs to be seen so much. It's just that chair's empty. So as long as that's not an issue for you all to have them there, it's just sort of a straight shot. Well, he did a second one. Good afternoon, Mr. Williams. I'm doing all right. Yourself? Good. This is a status conference on your case, so I can hear from your lawyer, and I heard you've now met Ms. Feely, lawyer number 3. She says she's staying. I'm counting on her to stay because I'm going to try your case. And we've got Mr. Abate, the prosecutor. I just want to make sure Ms. Feely has everything so that she can say ready when you and she believe is ready to try the case. So I wanted to have that conversation in your presence. We've got Mr. Abate here. Ms. Feely, anything you think is missing now that you've had a chance to work through the case file?
I think I have everything from the discovery perspective.
Okay, you had flagged just before we brought Mr. Williams out that he shared with you that an investigator showed up, did a buccal swab. Do we have results from the crime lab?
We do, Your Honor, and I apologize. I had sent them. I wasn't thinking. I forgot Ms. Patel doesn't work for the public defender's office anymore. So I will forward what I sent to the report to Ms. Feely.
Okay, so the GBI is done. We're not waiting on them. What about cell phones in this case?
So I actually just got off the phone with the Secret Service. They broke into both of the phones, and they expect that Friday they'll have all the dumps, so the extractions to me. If not, Monday was the latest. So once I get them, I can quickly upload them to Dropbox or evidence.com and send them over to both counsel.
And these were phones that were found in the back of the alleged victim's car or the car that Mr. Tolbert, someone was driving? They're phones that were found in a car.
The defendant's vehicle, the car that's seen on video surveillance, the defendants get out, approach the victims, and they get back in and flee.
Okay, and the phones are found in that car?
Yes.
Got it. Not on people, but in the vehicle. And you don't believe the phones belong to the victim? They just were in the car?
Right. I suspect belongs to the defendant.
Okay, and it's 2 phones.
Yes, sir.
All right. And you will have the contents of those extractions late this week, early next week. You'll push them to Ms. Feely and to Mr. Theory.
Yes.
Okay. Anything else you're aware of that the state has been working on?
No, Your Honor, and as I look through the phones, if I see anything that are of particular interest to me that I flag, I'll make sure to shortchange it and make sure both defense counsel knows that what I'm going to use. Kind of like how me and Ms. Probation and I did for schools.
Yeah, no, I appreciate that because who knows what all is in there. But if there are lots of pictures of pink elephants and you're not going to use them, we don't need to worry about those pictures. You could say, hey, the video that has your client doing X, that's what we're interested in.
Yeah.
Okay. So Ms. Feely, you will be getting today, it sounds like, the GBI results. And then soon, in the next few days, the result. These phones predate you, and there's been this ongoing effort of trying to crack them. Sounds like the Secret Service was successful. Whatever they get out of those phones, they'll get to the state, and then you'll be entitled to an image, the same image. That may be voluminous, and so I'll be respectful of your desire to want to get through it all. But Mr. Abate is committing to highlighting the parts that are of interest to the state. That doesn't mean there won't be other things out there that they didn't look at that you'd want to. So that'll take a little bit of time, I suspect. But that sounds like that's the universe. It would be phone dump, and the GBI results are going to be what they say. Your client's DNA was or wasn't on the bottle or the gun or the shell casing, whatever it was they were looking at. Okay. Anything else from the defense? If we assume you get the phone extraction information by early next week at the latest, if we're looking at when we can get Mr. Williams's case on a trial calendar such that you're comfortable saying ready, and that you've had enough time to work with Mr. Williams, what time frame are you thinking about? Would that be July or August or 2023?
I think July would be reasonable, assuming that there's nothing else that needs to be followed up on from the 2 things that I don't have.
Okay, got it. The state's intention is to try Mr. Williams and Mr. Tolbert together, or do you think that they have to be severed because of some evidence that you'd want to use?
I would say as of right now, my intention is to try them together. I'm undecided as to whether I'm actually going to use Mr. Tolbert's statement. If I do, there will be group issues. So obviously I would be forced to try them separately, and I would try Mr. Tolbert first.
Okay.
Yes. My preference is to not use the statement. The Jackson data would be the abundance of caution, not just to make sure we don't have the issues right before trial.
Right, just so everyone knows that it could come in should you choose to use it.
Yes.
Okay. All right, we'll need to get with Mr. Theory then, because I know he's climbing a bunch of steep learning curves. But he's actually asked if I would designate, hey, prioritize. If you've got these 5 murders, where do you want to start? And I'd be inclined to say Tolbert and maybe one other one, given Ms. Feely's announcement that she ought to be ready this summer. Be great if Mr. Theory was as well. All right, good. Mr. Williams, any questions for me? Okay, well, Ms. Feely will be circling back with you concerning whatever the GBI found, and I suspect in particular, whatever is in these phones, because you may be able to help her see real quickly on my phone, and then she can be less worried about what's in the phones. Yeah, you can. Yeah, you need to share with me the July calendar. We need enough dates. We have. Oh no, we'll talk about it later. We have 2 jury selection dates in July. Well, I guess no, we have one in late June. Okay, we'll talk about it. I think we do. I think July 11th. Remember, we switched. We grabbed Ellerby's date. We can talk about it. Because on the calendar it says criminal jury trial selection. Okay. Yeah, we should just talk about what will go on it. I don't think this would. Because that's when Darius getting married. Yeah, okay. All right, Mr. Williams, were you able to discuss with Ms. Feely what you wanted to? Great. Then she'll be out to see you once she gets these two things from the state. And then Ms. Feely, I will rely on you to proactively say, oh, based on what I got, I need to bring in an expert or this or that. Anything that would take you off course for a late July or early August, that's the date I'm looking at based on our trial calendars. The sooner you let us know, the better, because then if that is the right thing to do, we can take it off that and get folks focused on it, including you, on a different case to try in early August. Okay. All right. Thank you. So Jerry Lee Daniels was not brought over.
He was brought over.
Oh, he was?
Yes.
Okay, it's in big letters, do not transport.
Yes, Judge. We spoke to him. I emailed Ms. Nelson. I don't know if she got it. I can resend it. I'm having issues getting an answer.
She did get it and she forwarded it to me that he, Mr. Daniels, is someone who needs to go to Georgia Regional and he's in the queue, but here he sits.
Yes, Judge. And part of the issue is the 3 different doctors that I had been speaking with, they all asked me, please let us know when he's coming up on a calendar. And so I've been doing that for all the calendars and just nothing has happened. So I didn't know what the court thought might be the next.
What was the purpose of letting doctors know because he's coming up on a calendar?
They told me that they might be able to expedite where he is in the queue.
Okay.
Since he had court dates coming up.
So he's been evaluated for competency, found to be not competent at this time to the degree that they need to see if they can restore him. Have I already entered the order that says, hey, take him and restore him?
Yes, Judge. I think part of the confusion was the evaluation was done while Mr. Franklin was still on board. Then it came back when I came in, and then we did the order pretty soon after I came into this courtroom. And so
Okay.
we've just been waiting.
Were you able to interact with Mr. Daniels in a meaningful way?
We spoke to him
Okay.
a little bit. I don't know if I would call it meaningful.
All right. So I guess I'll reach out to DBHDD to see what maybe my asking will have a different effect. I just want to make sure I understood the posture. It is, we're waiting. Could you please come get him?
Yes.
Is there not an active restoration pod at the jail right now?
There is, and the contact that I had there, that's who actually told me to start emailing the doctors directly.
Okay.
So I'm not sure if they thought that maybe he just wasn't appropriate for the pod. I'm happy to email them again and see if that's changed.
Who are the doctors? Do you remember their names?
Yes, Dr. Risby, R-I-S-B-Y, Dr. Wright, W-R-I-G-H-T, and Dr. Oliver.
And they're all DBHDD doctors. Okay. All right. Ms. Charles, this may not be your case based on the charges.
It's my case, Your Honor.
Hey, Mr. Thomas, anything you want to add? I think we're stuck right now. Mr. Daniels needs to get some care elsewhere than at the county jail. And we're sort of beholden to when DBHDD says we can take him, but I wanted you to have a chance to weigh in.
I don't have anything to add, Your Honor. This is my first contact with the case, so it's good to get a status on where we are.
Okay. Well, where we are is where we were, I think, last time we talked about it, but I'm glad you now are plugged into it. And we'll see what we can do about getting Mr. Daniels relocated. All right. Next up is Mr. Cherry. Should we bring him on out?
Yes, please.
Let's do that, please.
Oh, no, he needs to go put in.
Ms. Charles, these are both your cases?
Bring in. Right here.
Ms. Rivers, are you ready to take this down?
Yes, Judge, I'm ready.
Thank you. We have two cases involving Mr. Cherry. It's 21 SC 177582 and 21 SC 179206. Mr. Cherry is here in court with his lawyer, Ms. Wood. Good afternoon, Mr. Cherry. Mr. Cherry nodded his head as if to say, good afternoon, Judge. We've got Ms. Charles here for the state. Mr. Cherry, you've got one case charging you with aggravated assault and another case charging you with 4 counts of aggravated assault. And today we are going to talk about whether the state has provided all the discovery to which you're entitled and where we're going next, because I don't have any motions that need to be heard. So it's time to get you a trial if that's what you want to do. But let me ask Ms. Charles first. Ms. Charles, is it your understanding that the state has complied with all of its discovery obligations in both cases?
Yes, except for speaking to Ms. Wood a couple of days ago, she asked for me to go back and see if there were any dash cams.
Please turn on your microphone.
I'm sorry.
Yep.
Yes, Your Honor.
Is that red or green?
It's green.
Great.
All the discovery that we currently have in our possession have been turned over to Ms. Wood. In our conversation on, was it Wednesday or Thursday? We talked about possibly a dash cam if that was available from College Park. So I will have to go back and talk to the office and see if that's available. Other than that, I believe that is all that is needed. We have sort of talked about the posture of the case and see if it was resolvable. I will bring to the court's attention, he does have an unindicted case.
Mr. Cherry has an unindicted case. Okay, what number is that?
20 CP 191307. That's an armed robbery.
Okay, that's a 20 CP.
Yes, Your Honor.
Okay, unindicted armed robbery. The dash cam video, is it your sense, Ms. Charles, that it would somehow be dispositive in the case ending in 206? Not that this defense isn't entitled to it no matter what, but is it the kind of thing that it doesn't make sense to move forward with 206 until you get the dash cam?
In my opinion, it wouldn't be necessarily dispositive. I think we have enough witnesses. We have multiple officers who can testify to the pursuit. There is enough of the pursuit, I believe, captured in some of the body cam that gives us the flavor of what came before and what came after. So I don't know that it would necessarily be dispositive, but I think it may help.
Assuming you're able to determine if there is dash cam, and if there is, that you get it to Ms. Wood in fairly short order, is the state ready to go forward with trial in Mr. Cherry's 2 cases?
Yes, I know we can be ready.
And which case would you try first?
At 21 SC 179206.
Okay, the one with the multiple officers.
Yes, Your Honor.
Okay. And the only thing you're aware of is the potential for dash cam video?
Yes, Your Honor.
Do you have any intel on the status of the 20 CP case, where it is in the mythical indictment queue?
No, Your Honor, it's sort of sitting. I looked into it and I didn't see anything additional since I last looked. It's just sort of waiting to be indicted.
Okay. All right. Ms. Wood.
Judge, what Ms. Charles has said is correct. We did discuss these cases, the dash camera, and then I think for the 582 case, she was going to check if the Pelco video existed from the jail, but I don't know if that exists or not.
What's Pelco?
The system they use at Rice Street, the video system.
This is different from Securus, which is the phone calls.
That's correct.
Yes, Judge.
Was the, oh, because there's an inmate. So 582 involves something that allegedly happened at the jail.
Yes, Judge,
Got it. So this would be footage of the alleged incident.
if it exists.
Okay, not footage of a video call that your client had with someone.
Right, the footage of an incident.
Okay, it's called Pelco?
Yes, Judge.
Huh, all right. Is that also something you're looking for, Ms. Charles?
Yes, Your Honor. It was referenced in the report, but sometimes if we don't ask for it to be saved within the period, it disappears.
Yep.
So we just want to circle back.
All right. It doesn't sound like if you get both, if both videos exist and you get them, that those videos would yield any evidentiary motions on your part. They would be evidence that would look good for you or for the state, however it might be, but it's not have to suppress this now. Is that a fair assessment?
Yes, Judge.
Okay. Any other reasons we couldn't put Mr. Cherry's cases on one of our upcoming trial calendars?
I think we could. There's some other pending matters Mr. Cherry has in other jurisdictions that Ms. Charles and I were looking into, but we could put this on the trial calendar.
Okay. Mr. Cherry, I don't know, Mr. Cherry has open cases in other jurisdictions or like the CP case? They're just,
There's an open indicted case in Clayton County.
okay. All right. Well, if we need to coordinate with that, I don't want us to run into a trial there. If that's something that's about to go to trial, if that's a shoplifting case, it'll get out of the way. If it's a 3 dead body murder case, we'll get out of the way. So you all should just let Ms. Nelson know so we can coordinate with the judge. You can coordinate with the prosecutor.
Yes, Your Honor.
All right. Mr. Chair, we've been talking about your cases a bit. Do you have any questions about anything we talked about?
I talked to my attorney.
Okay, good. That's a good person to talk to. I want you to know that I am interested in getting you into court to resolve your cases, whether that means a plea or it means a trial. You're entitled to the trial. You don't have to go to trial. You could resolve the cases. It sounds like there are a few moving parts for you. This unindicted case in Fulton is a serious charge. It may be a weak case. I don't know. I don't know why it's not yet indicted. It's got to be approaching 2 years old. And then you've got something in Clayton. I don't know how serious that is either. You may want to try to get things resolved globally. You may not, but Ms. Wood can help you with that. I can only work on the 2 cases here. I need you to turn that microphone back on. That's all right, for the whole courtroom. That's okay. It was smart to turn it off for that point. So what I'm going to do is work with Ms. Nelson to get this on an upcoming trial calendar, because I'm hearing both sides say trial ready, but for some potential video that may not even exist. But if it does, you're entitled to it. But that doesn't need to hold up putting this down for trial.
Yes, sir.
Okay, great. So Mr. Cherry, keep talking with Ms. Wood about what your plans are. And when I see you next, it'll either be because Ms. Wood has said we want to do a plea, or it'll be time to pick a jury in your case.
Okay.
All right, thanks.
I'll get that for you. Okay. Thank you, Judge.
You're welcome. Cedric Johnson? Was this the one with the immunity motion? And it is in fact immunity. It just wasn't what I was thinking. Like, how does immunity work here? But it's a different species of immunity.
Trying to be creative,
Yes.
Judge.
So you're saying Cedric Johnson is on the Zoom. There he is. Let's get him. There he is. Hey, Mr. Johnson, can you hear me? Okay, I saw your mouth say yes, sir. I didn't hear you, but as long as you can hear us, we're good. Okay. If you can't hear us, raise your hand, but right now you seem to be able to hear us. There was a motion, the immunity motion, it was withdrawn, and we just need to talk about discovery and are we ready to try this case or otherwise resolve it?
Judge, this case is like 98% ready to be resolved. He was referred to drug court. Mrs. Strunk let me know he is appropriate for drug court. She just needed those medicals done. And since he's out of custody, it's on him to get that done. I spoke to Mr. Johnson on Friday. The reason that he's been delayed is his brother had a very serious stroke. And so that's sort of, he's a caregiver. So he kind of got off track with those medicals. I asked him to please prioritize those this week. Talked to Mrs. Strunk this morning. She said as soon as she gets those in, she'll get like dates or orders, whatever we need. So
would this be a diversionary entrance or it would be part of a plea to these charges?
Part of a plea.
Okay. So maybe what we ought to do to help focus Mr. Johnson on this is to set a plea date in the near term. It sounds like I'm not dictating terms to the state, but if Ms. Charles agreed that drug court was the right destination for Mr. Johnson, then we could take the plea. And if Mr. Johnson had not yet obtained the medicals, but hopefully he would before the plea, that would be the initial condition of his probation, that he's got only X days to take care of that. And then he's sideways with probation, and then he'd need to get into drug court. I just don't want this to linger. And I appreciate that Mr. Johnson's focused on family. That's important, taking care of his brother. Did Ms. Sistrunk identify a place that Mr. Johnson could go to take care of the medical paperwork that's free of charge? Or is this something where he needs to find $300 to go see a doctor?
So she had indicated to me that she had forwarded him all of the necessary information as to where to do it at, and she was just waiting on him to get it completed. So I don't know the names of those places, but I'm happy to find out.
Well, I know Mercy Care is usually a good partner with drug court, and that's where folks can go. Mr. Johnson, do you know where you need to go to get your medicals done? Okay. I can't hear you because I don't think there's audio. Why don't you hold up one finger if you know where you need to go, two fingers if you don't know where you need to go. Two. Okay. Well, we'll work on that. Ms. Wood, you have good contact information for Mr. Johnson?
I do, Judge.
And I'm happy to loop Ms. Sistrunk in, but it sounds like you can do that. We may need to channel him that information again. If we get Mr. Johnson's case on for a plea in the next few weeks, does that seem like enough time?
Absolutely, Judge.
Mr. Johnson, if we got you again, the information about where you need to go to take these few medical tests, you think you could take care of that in the next couple of weeks? Yes, sir. Excellent. A 1. I like that. 1 is a good number. All right. Then we'll do that. Do we have a good address for Mr. Johnson?
I do, Judge. I have all of the contact information for him.
Excellent. Then we'll set this down for a plea. I think, let me ask the state, Ms. Charles, anything Ms. Wood said about how this case is likely to work out that you disagree with?
No, Your Honor. I'm in agreement.
Okay. All right. Mr. Johnson, I would ask you if you have any questions, but unless your question involves the number 2 or the number 1, I won't be able to follow along. So what you should do is reach out to Ms. Wood if you've got any questions. She's going to get you that information again on where to go to get those medical tests, because you got to have those before you can start drug court. Okay? Excellent. All right, Mr. Johnson, thank you for dialing in. Is he free to go?
He's good, Judge.
You are. All right. Take care, Mr. Johnson. Best of luck to your brother. All right, next case is Mr. Abate's. It involves 3 defendants. I think it does. Carrie Henderson is the first. Is Carrie Henderson here? Hello, Ms. Henderson. And for whatever reason, in a case with a defendant charged with murder, the public defender's office has the defendant charged with false statements. That's an interesting allocation of resources, but you inherited it.
This is never before my time, Your Honor. Yes, that is Henderson.
All right. I don't have any motions in the docket. Any concerns about discovery in connection with Ms. Henderson, Ms. Feely?
Not at this time, and I've only spoken with Ms. Henderson by phone, so I do need to go over everything with her at some point, but we just wanted to kind of an update from the state's perspective about when she's obviously a small fish in a much bigger case. She's only listed in 2 counts of the indictment, so. But I do need a chance to speak with her in more detail.
Got it. Okay. Well, she's here now, so this would be one opportunity. But as long as you guys know how to reach each other, we can make that happen. Mr. Abate, if this first, how are you doing with discovery in this case?
I believe if everything we have has been turned over, I don't, off the top of my head, know of any outstanding discovery.
It's not a, I hope we can crack these phones case.
We don't, not in this situation.
Okay. Assuming that Mr. Parks wants to go to trial, or Mr. Phillips, or both, do you envision Ms. Henderson going to trial with them? Or are there severance issues from your perspective, given what they're charged with versus what Ms. Henderson is charged with?
I would not intend Ms. Henderson to be tried if there's a trial with the other 2 co-defendants.
Okay.
I'll be blunt. It's the state's intention most likely to use her as a cooperating co-conspirator or witness, and try to resolve her case.
Okay. In a nutshell, what is the false statement allegation about, if you remember?
I'll be honest, I don't remember. I believe it's as it pertains to where one of the defendants was. If that's my recollection.
Okay. I won't hold you to it, but it means it's obviously connected in some way to the other allegations.
Yes.
Okay.
But it's minor in connection to everything.
Got it. Okay. Well, Ms. Feely, you drew the right hand in this particular case. Please do work with Ms. Henderson. And it sounds like what will drive this forward is when Mr. Parks and Mr. Phillips are ready to go to trial. We'll see what happens. Okay, great. Mr. Parks is next. His lawyer is Mr. Theory. And what did his email say other than not ready? Okay, he is going to file an entry of appearance. And he's not sure there won't be particularized motions. He joined this new role about a week before the motions deadline occurred. So I'm gonna give him a chance to digest all that. Do you happen to know if there are anything in connection with Mr. Parks' alleged confession or anything that would lead to motions?
I don't believe there's an alleged confession. There may be a motion to suppress certain items of evidence that were seized in relation to his arrest, but I don't recall a statement being made. But I could be wrong because they all blend together.
Okay. Well, I'll reach out to you and Mr. Theory to get him to file his entry if he hasn't yet, and to get a sense from him when he could say yay or nay to evidentiary motions.
And I will follow up to make sure that he has all the items of discovery that he would have received from prior counsel. I might, in an abundance of caution, just reserve it all just to avoid any issues.
Sure. Okay, great. That brings us to the third co-defendant, Demario Phillips. He's represented by Ms. Upshaw. Who I think is one of the new C3 lawyers. Well, Mr. Phillips should be in custody, so he's here. So if you don't mind reaching out to Ms. Upshaw, see if she can join us. Our interpreter has arrived. So let's get Mr. Toray out here. Would that be helpful?
What is the name of the defendant?
I don't. Do we get an update from Mr. Melnick? No. Okay. So we need a chair for the interpreter. Good afternoon, Mr. Toray. I'm Judge McBurney. It's nice to meet you. Mr. Toray, I was talking with your lawyer, Ms. Feely, about your case. And she told me that she wants to spend a little time with you and with a colleague of hers to see if they can find a program in which you could participate if you work out your case. Does that make sense?
I don't know what they want me to, I don't know.
Okay, so you'll know more when they talk to you? They'll come visit you with an interpreter. And they'll talk with you about ideas to help you if you resolve your case.
Okay.
Ms. Feely, when do you think you and Ms. Patterson would be able to meet with Mr. Toray?
I will have to coordinate with an investigator, but I would expect to do it later this week.
Okay. So, Mr. Toray, they'll come visit you this week or next week to have that conversation.
Okay.
Will you talk with them when they show up? Good. Thank you for doing that. After you talk with them, we'll meet again to talk about your case.
Yes.
Do you have any questions for me?
No.
Are you taking your medicine each day?
Yes.
Good. Keep taking your medicine. Ms. Charles, anything in connection with Mr. Toray's case?
No, Your Honor. Just
Have you and Ms. Feely talked about resolutions, or they will be coming to you with a plan?
I have been talking with Ms. Wood about it, but we're on the same page. We are keen to resolve the case once we can get a plan of action in place.
Okay,
We can do that.
so I think we're all agreed that we need to find a good program or plan for Mr. Toray, and that will help resolve his case. All right, no pressure, Ms. Patterson. Ms. Feely, anything else on behalf of Mr. Toray? What is a reasonable deadline to try to bring Mr. Toray back here to talk about his case?
Ms. Patterson was saying, and she's holding up before, about 4 weeks with the accommodations that she had been looking into.
Okay.
And I'm trying now to email the investigator so I can go make that happen this week.
So we won't set anything until July at the earliest. That gets you a month to work through it. If we need to push it further out, let's do that. But if we don't hear from you, we'll assume you've been able to arrange some things that meet with general consent from the state, and then we can get Mr. Toray back here. All right. Thank you, Mr. Toray.
Yes, thank you.
Yes, ma'am. Thank you for showing up. Appreciate it. So I don't know if anyone was here for Mr. Phillips, but his lawyer is on leave today, so we won't be bringing him out. And Mr. Bate, that may be it for you. I don't know if you had other cases, but that's the co-defendant to Mr. Parks. So we'll have to reset this status conference. Okay, have you and Ms. Upshaw ever connected? I don't think I've met Ms. Upshaw.
I have not.
Okay. All right. What did we hear from Mr. Melnick? Anything? Oh, he did. Okay. We can reset it.
Yeah, I asked that minute, you want to reset or?
All right. If anyone is here for Mr. Ransom, his attorney isn't able to join us today, so we won't be meeting with Mr. Ransom. We'll reset that. How about D'Angelos Robertson?
Oh.
I heard you say you are his mother. Where's Mr. Robertson? Oh, restroom. Okay, that's fair. He can do that. He'll come back. You don't have to run in the restroom. We'll come back. How about Shirley Simmons? There's Miss Simmons. Hello, Miss Simmons.
Judge, that's my client. I have a new offer from the state, so if we could just speak with her, and I'd like to see if we can resolve this one.
That'd be great. Let me call one more name, and that you can talk with Ms. Simmons. We'll wait for Mr. Robertson to come back from the restroom. Last one on the 1 o'clock is Mr. Copeland. Mr. Okeke, are you there?
Yes, Your Honor. How are you?
Fine. Is that Mr. Copeland with you?
But of course.
Of course. All right. Let me put the spotlight on. There you guys are. Woo, that's a nice polka dot shirt you've got there.
Oh, thank you, sir.
Let's
as good as you.
Well, hey, not everyone. Let's talk about this. Who represents the state?
Your Honor, I'm standing in for ADA Hall, standing in for Mr. Whitenhour.
All right. So, Mr. Okeke, Mr. Whitenhour is the prosecutor who would normally be handling this. He is on paternity leave. His substitute is ill today. Her substitute is right here in court. So we've got people to talk about the case. My review of the docket shows that there are no motions that I need to hear. And so we either need to set this case down for trial, which I'm happy to do, or for a plea date sometime soon, unless there's a discovery issue that I don't know about. So why don't you start, Mr. Okeke, and let me know where you are.
Your Honor, we are set for trial.
Okay. How long do you think trial would last?
Well, on our side, I'll say about 2 hours.
Okay, not long. I'm looking at the charges. My guess is the state's case wouldn't be all that very long either. So you're ready to go. We just need to get you a trial date. Is that a fair statement, Mr. Okeke?
Fair enough, sir.
Okay. Ms. Charles, you're now in a position to commit Ms. Hall and Mr. Whitenhour. Is the state ready?
Yes, Your Honor.
Okay. Mr. Okeke, have you been able to have any type of discussion with one of the prosecutors about resolving it short of trial? Or this is one of those cases where if they want to dismiss, they can dismiss. Otherwise, it needs to be a trial.
The latter. They want to dismiss, they can dismiss. Otherwise, we want a trial.
Got it.
Okay. Jury trial, of course.
Understood. Well, I don't know what's so bad about a bench trial, but yes, it would be a jury trial. All right. We will get it on one of our calendars coming up. Let me do one thing with Mr. Copeland being there with you. So, Mr. Copeland, I'm just looking at your bond, make sure we're straight on that. You received a bond back in November and you needed to stay away from Ms. Carter and you needed to stay away from a residence for a little while until Ms. Carter was no longer at that residence. Is that residence in Fairburn? Is that your home?
Yes, Your Honor. I own the home.
Okay, and do you live there now?
Yes, Your Honor.
Okay, and you're staying away from Ms. Carter?
Hey, you ain't got to trust me with that. I've tried a long way, 1,000 miles away.
Yes, we did not.
Yeah, yes, Your Honor.
Okay, got it. I just want to make sure. Then we're good. We'll put this on a trial calendar. Mr. Okeke will get notice of that. He'll let you know. You'll get notice of it. And we'll see you either for a dismissal or for a jury trial.
Thank you, Your Honor.
Thank you. Thanks for your patience. You guys are free to go.
Thank you, Your Honor.
So, Ms. Wood, why don't you speak with Ms. Simmons? Is Mr. Robertson back? He is. Don't speak with Ms. Simmons. Great. You talk with Ms. Simmons. Mr. Robertson, why don't you come on up here, please?
Hey, Your Honor, after we're done with Mr. Robinson, can we circle back to position 2? I think we have an announcement in that case.
Yep, hold on one sec. Can you leave your backpack? You don't need to bring your backpack with you, just you. Thank you. Yes, I didn't mean to leave you hanging on this session. So Mr. Myron, and I forgot we may need to bring Mr. Myron out so he can hear certain things. But I just got Mr. Robinson all the way up here. Can we, it won't take very long. We're going to handle that, Mr. Thomas, and then we'll circle back to Mr. Myron, okay?
All right, thank you, Your Honor.
We won't let Ms. Wood leave. All right, so this is Mr. Robinson's case. It says Whitenauer as well. Ms. Patel, you've been sitting here quietly. You're going to step in on this one?
Yes, this is my case.
Got it. Excellent. So, Ms. Wood, how are you doing with discovery?
Judge, the discovery was originally served on an attorney who's no longer with our office. We've ironed that out today. Ms. Patel has served it all on me, so I just need a bit of time to review it and then, go over it with Mr. Robertson, and then we can move forward.
Okay. Your sense is that it's complete discovery, or?
Yes, it is. And I'm going to work on giving Ms. Woods an offer in the next 2 weeks.
Okay.
On this case.
Anything in the discovery you can think of, Ms. Patel, that would prompt, well, I guess there weren't particularized motions filed, and that would have been either your obligation or a predecessor, the other Ms. Patel. So someone's review of the discovery was that good case, bad case, there are no particularized motions.
Yes, Judge.
Okay. All right. So then this is a case we could move to a trial calendar, which we'll do. If before then, Ms. Patel's offer is something that sparks Mr. Robertson's interest, let's get Mr. Robinson back in here and we'll see if we can sort the case out. But I'm viewing it as ready for trial. Is that a fair statement for the defense?
Yes, Judge.
All right, Ms. Patel?
Yes.
Any witnesses who need to come from far away?
No.
Don't need a special setting?
No.
Okay. Great. Mr. Robertson, do you have any questions about your case? Nope. You'll keep talking with Ms. Wood about it?
Yes, sir.
Sounds good. All right. Thank you.
So you're free to go. Okay.
All right. Let's go back to Wallace Myron. Ms. Wood, did you and Mr. Thomas end up talking about Wallace Myron, or I guess he's sort of new to it?
It's not going to resolve today, so we can bring Mr. Wallace out.
Is his last name Wallace or Myron?
I think it's backwards on the court stuff. I think the last name is Wallace.
Okay. Thank you.
Judge, that concludes my business. May I be excused?
Yes, ma'am. Thank you. Any cases that you are superseding indictments on and we don't know about it yet, that are stuck somewhere?
No.
Okay, good.
Oh, we can go by them.
It's Mr. Wallace.
Yes, sir.
Not Mr. Myron.
No, sir.
That's what I'm remembering. Okay, Ms. Wood corrected me because unfortunately you're in the system as Wallace Myron. We got the right person. It's just they flipped things around. So Mr. Wallace, good to see you. We're talking today about making sure your case is moving forward. There were no motions filed by your lawyers, meaning they looked at discovery and didn't find anything where there ought to be a motion to suppress anything like that, which means it's now time to get your case on a trial calendar. Doesn't mean you're going to have a trial, but that's the way to keep it moving. And I just want to let you know that, and to give the lawyers a chance to say, whoa, not so fast. There's still X or Y or Z we need to deal with. I'm going to start with your lawyer, Ms. Wood. How are you doing with discovery?
I believe I have everything from 88 BESA. The only thing that I was going to ask Mr. Thomas about, and I think he might not have it, is if he had the color photos from discovery. But I have a feeling those may not exist, but otherwise, I believe I have everything.
Okay. Mr. Thomas, if you wouldn't mind in the next few days checking your case file to see if there are color versions of what are these photos of?
It's hard to tell, Judge.
Okay.
I'm not sure.
Your Honor, it looks like it might be photos of the injuries that are attached to the police report.
Not sure.
Okay.
So I can check. I'll check and see if I can find the color photos if they do still exist.
Got it.
I asked for about 2 weeks to comb through and make sure that we have everything, and then make sure I can talk to the victim, talk to the officers, and get an offer out.
Got it. But otherwise, the state's ready to go.
Yes, Your Honor.
Okay. All right. So, Mr. Wallace, I'm going to put your case on one of our upcoming trial calendars. Again, it doesn't mean it has to be a trial, but it means you'll get one if the state comes back and says, well, we offer Mr. Wallace 10,000 years. You may say, I'm not interested in 10,000 years. I'd rather go to trial. You can have a trial. But it may well be that the state is here and you're here, and you either can negotiate through Ms. Wood a resolution, or you have a blind plea where your lawyer recommends X, the state recommends more than X, and I figure out what I think the appropriate number is based on the facts and circumstances of the case. But if it's not going to work out, then you need a trial, and we need to make that happen. And that's what we'll do. Okay?
Yes, sir.
Any questions about any of that?
No, sir. Is there anything about a bond? I've been here 5 months without a bond.
So you can talk to Ms. Wood about that, and if she thinks it makes sense for you to file if she thinks it makes sense to file a motion for bond, she can. We lost track of you for a while. That's one reason why you're in a no bond status. You can talk to Ms. Wood about that. The other thing I'll tell you is, because I think we're ready to get you a trial, what I would likely do instead of saying, well, let's give them a bond and then wait for trials, let's just do the trial. Because if you're found not guilty, you don't need a bond. You're done. Go. If you're found guilty, I shouldn't have given you a bond anyway. So we're that close to being ready that my sense is getting you on a trial calendar rather than a bond calendar makes more sense. But that's not my call. You and Ms. Wood will talk about it. And if you are persuasive and the facts are there, she may say, you know what, let's have that bond hearing. And we can do it. There's no reason we can't do a bond hearing just before a trial calendar. They just aren't always real productive, because my response will be, let's do the trial.
If the trial calendar is soon, then I don't understand without a bond being.
And if it's not soon, if for whatever reason we learn from the state, those color photos is going to take 4 months to get the color photos, but they're important. In other words, you'd want them for the trial, then we should talk about bond. You shouldn't be sitting around for 4 months because the state can't get color photos. I'm not saying they can't, it may not exist, but if something like that comes up, then we should have a conversation about bond, okay? All right, sounds like a plan. We'll get this on a trial calendar soon. Mr. Thomas is gonna spend a week or so looking through the file, making sure he has everything he thinks he should get, and also that Ms. Wood has everything else. Mr. Thomas, anything else from the state on Mr. Wallace's case?
Nothing from the state, Your Honor. Thank you.
Ms. Wood?
No, Your Honor.
Okay, thanks.
All right,
Mr.
Your Honor, may I
Tom,
be excused?
no, not quite. I need to know from you and Ms. Charles, what's happening with Mr. Sims? Because Mr. Sims is on our June 2 trial calendar. I get jurors on June 2 to try Mr. Sims or to try Lefty Hodge.
Be a global resolution tomorrow, a plea. I think Mr. Thomas said he might be in a different courtroom, so I'll take the plea in his case on his behalf.
So you're deputizing Ms. Charles to play the role of Tyler Thomas?
That's correct, Your Honor.
Okay, excellent. And you said that's tomorrow?
Yes, Your Honor.
Okay.
You want that to dismiss it?
Whatever. I mean, I got the magic sticky note that says, wait a minute, don't let Thomas leave till he knows he could be going to trial on June 2. All right, I'm gonna keep the sticky note up here just in case Mr. Sims doesn't come in tomorrow to take care of business. But if Ms. Charles, you're the only prosecutor available, you and Mr. Thomas have spoken, so we're not gonna get from Mr. Matthews, whoa, wait a minute, Mr. Thomas said I got a gold ribbon for the DV case.
No, Your Honor.
Okay,
We've
All right.
we've spoken.
good. All right, then Mr. Thomas, you are free to go.
All right, thank you, Your Honor. You have a good day.
You too. Yeah, we haven't gotten to that calendar yet. We've got the probation revocation calendar is next, but we're not there quite yet because we need to see what we're going to do with Ms. Simmons. And we can take a break if you need a chance to talk with her.
I did not have a chance to talk with her. I was gonna.
But you dispatched the intern.
I did. She did speak with her.
Okay.
Judge, whatever the court would like to do, I'm happy to talk to her or do the call of this calendar.
Why don't we call it to see if we're going to have a full-blown revocation or if things have been negotiated or what? Let me just make notes about Mr. Wallace here. Okay, so our probation revocation calendar, we've got Mario Copeland. And if the defense attorneys could let me know if they've got the case, because some of the, like this is Brian Hobbs. I know Brian, he was the senior PD with me for many years. He's now in private practice, but I'm assuming he's not on the case.
I believe this would be mine, Judge.
Okay. And what do you, Mr. Copeland's been in for a while. Oh, because he's got a CP matter also.
Judge, I spoke to him. He is interested in resolving just the probation matter. I don't think it's going to be negotiated, but I think we can work through this one today.
Okay, so we'll do revocation today for Mr. Copeland. How about Dante Buford?
Judge, I originally thought that this was not going to be ours. However, I did some investigating. He's got 4 open cases with our office. 2 of those are in Judge Barwick's courtroom, and then 2 are unindicted.
Okay,
I just reached out to the public defender in Judge Barwick's courtroom to see kind of where they are. I don't know if we're going to be able to move forward on the revocation today for Mr. Buford based on my conversation.
is the basis for revocation one or more of these newer cases?
Yes.
Okay, understood. Well, I guess Ms. Charles, with Mr. Buford, the state can say, that's fascinating, but we want to do a revocation hearing because that may help dislodge these other cases. The state could also say, you know what, we don't need to pursue the revocation right now, unless the only thing holding Mr. Buford in is the revocation warrant. That's sometimes the crossroads we reach, and then that That's different. If Mr. Buford can't go anywhere because Judge Barwick has said no bond, then it's a different situation.
Isn't some of the revocations was keeping him in? I think that the bond is set in both of the secret cases.
Yeah, he just have a bond. I'm not sure if he can make it, but you're correct.
Yes.
Okay, then I'll just need to know, Mr. Buford can hear you say this, if you want to set this down for an evidentiary hearing. I don't know what any of his other cases are. It may be as simple as you bring in one officer saying, yeah, he had a gun and he's a felon, and that's the basis to revoke. But you need to decide what you want to do, because if the only thing preventing Mr. Buford from getting out, if he had enough money, is this warrant, then we need to be intentional about how we do this rather than, let's just see what happens in Judge Barwick's courtroom.
I had a number that I would like to revoke, if Ms. Wood is in agreement to, we can talk about it.
Okay, well, why don't you talk, we're going to take a brief break in a minute so that they can talk with Ms. Simmons. I just wanted to know. So we're not quite sure what we're going to do with Mr. Buford. Earl Wade, I will bring out and let him know that he needs a lawyer for his unindicted murder. That won't be you all, is that right?
Correct.
That's correct.
Okay. Linda Harris.
She'll be my judge.
Okay, she's got 2 CPs.
One of which is a no bond.
Okay,
I did want to inquire with Madam Probation, how much time is left on the probation matter? Oh. Thank you.
done. Madam Probation number 2. Okay, so there's a little bit.
There is a little bit, Judge. We may be able to resolve this with a blind stipulation, Judge.
Okay.
Ms. Harris is here to be seen today.
Okay, and then Shabazz Morgan, been in jail for a while.
Same announcement. He'll be mine. I think we can go non-negotiated on this revocation.
Okay, great. Ms. Feely is exempt from having to do probation matters, or these just all happen to be yours? All right, then I'll take a quick break. If you all would please talk with Ms. Simmons, and then Ms. Charles, if you could think a little bit about Mr. Buford and maybe talk to the PDs about that. And we'll do Ms. Harris last, because that's what Deputy Gordon asked for. Anything else we need to do in a? Sure, I can talk. Mr. Wade will take 2 seconds. He in particular, or you're just trying to move a group of folks? Got it.
Okay, I think that's what she said. Yeah.
Why are you guys not on Earl Wade's murder case?
We have a co-defendant, Judge.
Co-defendant.
For his murder. Mike Ratloff has.
Oh, that's right. You showed me. You showed me. Okay. Yeah, right there. Hey, Mr. Wade, how you doing? Good. You were brought over today because I thought we might be able to work through, you have 2 probation revocations. One was a case Mr. Adams handled, and one I think the public defender handled, but it was old, doesn't really matter who had that older case. You've got a much more serious charge holding you in right now, and we need to get you a lawyer for that case. The public defender represents your co-defendant on that unindicted murder. It doesn't make sense to, and Mr. Adams informed me, he was not retained to handle your revocation on the case you just had with him where you pled out. So we need to figure out the best way to get you a lawyer, unless you're going to hire a lawyer for your new charges. But that's the person who ought to talk with you about what to do with these 2 revocations and your new charges. But today, because you don't have a lawyer, we can't really move forward with those. But I wanted to tell you that, and you could let me know. Yeah, actually, I'm planning on hiring so-and-so, or I'm out of money. I was going to hire someone, but not anymore. I can't hear you. Okay. I don't know that I'll be the appointer, but I'll see what I can do about getting a lawyer appointed to your unindicted case. And then that lawyer can talk with you and then ultimately with me about what to do with your 2 probation matters. While you're standing right there, let me just get from Ms. Tucson, how much time remains in Mr. Wade's 2 cases? Because if it's 2 months, we don't really need to worry about this.
Okay, on 18 SC 161416, he has 6 years, 28 days remaining. And on 22 SC 181208, 3 years, 8 months, 19 days.
Okay. Those are large enough numbers that we'll need to figure out who's going to represent Mr. Wade and go from there. All right. I just want to give you that update since Mr. Adams is out of the mix and you don't have a lawyer on your new charges. We'll figure out what we're going to do. And if it's going to involve these old cases, we'll bring you back here. If it's your new case, that's going to be randomly assigned to a judge. Could be me, could be one of 14 other judges. Okay. Okay. I'll come back out in a little bit. We'll take care of things. Who are you here for? Oh, you're here with Ms. Simmons? Okay, great.
Oh, you don't feel like walking, you don't feel like walking.
We can have lunch. I do 2 o'clock dinner.
You know they do it. Yes, you're gonna, I didn't know what order you wanted to go in. Okay. Great. Yeah, that's awesome. I got a retaining wall, so I didn't even need a back for my okay. Yeah. I'll do it back over that. Yes. I'm gonna resend that. Yeah. All of it. This one say yes. Yes. Okay. Thank you. That's probably not make my mind right. First, I played I need to be heard. So because what the situation there, whether he could really is a nice positive, or he could let me really watching real quick to see if you guys want to do something with each other, but you know, like we have thank you. Oh, you can do a quick update. Oh, Molly's gonna, one of these people, one more thing.
I need to.
Copeland.
There's one of the charges. I'm gonna have to talk to Siri. It's just really good.
I may use that. What? Because I can get it.
Still gotta go. Well, it will get stuck in there, if it get open, it's already down. But you have to go get a key to change that. Yeah, just like it's. Go ahead, and we're talking.
Say $2.
You gonna bring one over?
Yeah.
Top.
He said, talk to me with you.
Come out.
You know, no.
Yeah. Yeah.
Nah, you gonna sign it.
So what do you?
Yeah.
Okay.
So, what's up? Sergeant Fluent, how y'all looking with any y'all good? Y'all- Most of them down?
Yeah, well, yeah.
I know.
No, set a deadline. I was gonna cancel.
So are you gonna ask for a
You.
full hearing or just gonna be non-negotiated?
Since when?
On Copeland,
No.
we'll just go non-negotiated. I think, yeah, it's the quickest way to do it.
So then down to you to ask if you want a full hearing?
What is it?
That's true. I know you can-
Yes,
you know you can-
view for
yeah,
hearing
just about-
and then-
Right. Right. See you. Everybody needs.
Yeah, so non-negotiated on all.
He had an attitude when he came back.
She stepped outside because it's too cold.
Oh, okay.
So I need your thoughts before we bring in whoever we're doing next on Mr. Cherry.
Have you seen my?
I did. So that's why I want to just get, this will come up again with other folks. He has a much larger fish to fry in Clayton County.
Yes.
Indicted or unindicted?
Indicted.
Indicted. So, but he's got these two open cases that are going to burn a hole in our pocketbook until we deal with them. I don't know why Mr. Cherry would want to resolve these short of trial here, given that he's got a 15 count murder case in Clayton County. So nor do I want either of you to get ready to try the case and actually try it. Like, let's just hypothetically, it's the one thing that is still ready because people have conflicts for other cases on a trial calendar. I don't know that it's the best use of our time. They sound serious, aggravated assault. I don't want to hear the facts, but they're not murder. So do we put his two cases sort of like we did with, I'm not picking on Harrison Trim, but we will sort those out. His cases per Mr. Franklin got put on judicial hold because he didn't want Mr. Trim to be the test case post-COVID, when we reopened, which is great. And he did that for a number of folks. I'm wondering if we want to do that with Mr. Cherry, is put his cases on judicial hold, but with a tickler that we check every 3 months what's going on in Clayton. It's what we did with John Connor. I don't know which of you two has John Connor's case, because he was supposedly in Douglas County going to be prosecuted for almost the same stuff, same alleged victim, et cetera. And so Ms. McCauley, having heard that from the Douglas County DA's office, said, just freeze this one. But why would we go forward? They're going to go first. Right. And if he's convicted, she said, we'll null pros, whatever. Then Douglas null pros. And so we've got Mr. Connor. But I'm wondering if we want to do something like that with Mr. Cherry. I don't mean to say we forget about him. And frankly, he's in our custody, which means we need to do something. I certainly don't want this guy getting a bond. But maybe Clayton would see to that as well. So let me start with what is the most efficient? Do you all agree that getting him on a trial calendar is not efficient? Or yeah, actually he'll work these cases out, which is fine with me. I don't know. I'm not asking you to reveal client confidences. It's more, what's the way to manage this?
Well, I do know that some of the previous attorneys from our office had been hoping that Clayton would swoop in and get him. If we had some type of hold on these cases on Fulton, he could go to Clayton and handle that case. He also has a Jacksonville, Florida hold for similar charges. So just giving you some flavor, Judge. So I don't know how, if that's even possible. I know the last time that we had talked, we didn't know if it was indicted. And then today I did confirm with the clerk's office that it's indicted down there. So I don't know if that would speed up things for his Clayton County case now that we know which courtroom it's assigned to.
What would speed it up?
If we can somehow reach out, I think we were looking to see if we could find out who the prosecutor is down there. To see if there's anything we can do about getting him
To Clayton.
to Clayton.
Yeah, we can get him to Clayton, but Clayton would need to say we want him. I don't know why they wouldn't, given that he's been indicted now. I would assume that Judge X wants to have an arraignment and then move that along. So why don't we work on that a little bit? Is there any objection, Ms. Wood, if the way we handle his cases, assuming we can get him to Clayton, is that we then put him on judicial hold to be removed from judicial hold as soon as you were to say, hey, I don't know what they're doing in Clayton, but they're not moving fast. And Mr. Cherry wants to deal with these cases. We bring him back from Clayton. He could come here and plead or have a trial. He wanted a trial, it sounded like, or at least he wanted not to resolve them. And the state has made clear they would do the case with the 4 aggravated assault on officers. Does that work?
Yes, Judge.
Okay, all right. Until Clayton dismisses.
Jacksonville, Florida, concerned. Thank you so much.
What happened with Miss Simmons? She's not here anymore.
She's in the hallway, Judge. She's gonna be a plea.
Great. Oh, she's cold. That's who went outside. I guess Deputy Gordon was like, yeah, she's outside. She's cold. I didn't know who he was talking about. We can handle things in whatever order you want. We've got some probation matters to work through. We've got Miss Simmons's case.
I think we can take Ms. Simmons first.
Great. Let's do that.
Judge, is it okay that we did not fill out this, but we went over it for the most part?
Did I mention we got Ricky Wolf's murder?
Yes, you did. Can we do something similar? Something that is not willing to meet me halfway. I'm the smaller one.
Yeah, we'll need to talk to him. I assume. Hi, Miss Simmons. You should come on up and stand with Ms. Wood. Is Mr. Menendez going to be representing Mr. Wolf in the murder case? Okay, that's probably what we'll do, but he needs to green light that as well. Okay.
I do it.
Hey, how are you?
Okay.
Good. Ms. Rivers, are you ready?
I'm ready, Judge.
Okay. This is position 14 on our status conference calendar, State versus Shirley Simmons. Ms. Simmons is standing up at the podium with her lawyer, Ms. Wood. Ms. Charles is the prosecutor. And as I understand, Ms. Simmons, you're prepared to resolve your case today. Is that correct?
Mm-hmm.
Mm-hmm. So when you're answering questions, you don't need to have the sir part in there, but I'll need you to say yes or no, because the court reporter, she's not gonna, was that a mm-mm or a mm-hmm? So we don't want to be guessing. So it's yes, no, maybe, I don't understand, but we'll get the full words out. Ms. Charles is going to put you under oath in just a moment. Once you're under oath, it's important that you answer all of her questions and mine truthfully and completely. And Ms. Simmons, it is no less important that you let Ms. Wood know if you have questions of your own. This is your plea, not mine, not Ms. Charles's. So if something happens that you don't understand, or, hey, wait, that's not what Ms. Wood told me, then you should say, wait, I've got a question. And then I'll try to answer it, or Ms. Wood will try to answer it. Then we'll keep going. Will you do that?
Yes.
Okay. Then Ms. Charles, when you're ready.
Thank you, Your Honor. Prior to proceeding with the plea, the state will be moving to reduce the charge from aggravated assault to misdemeanor battery, code section 16-523.
Got it.
Ms. Simmons, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Nothing but the truth.
May I lower your hand? You put it down. Thank you. Please state your true, correct, and legal name.
Shirley Ann Simmons.
Are you at this time taking or under the influence of any alcohol,
Mm-mm.
drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
I went to 12th grade with Gladys Knight.
How old are you?
I'm 76.
Are you able to read, write, and understand the English language?
Yes,
Ms. Simmons, did you graduate from Gladys Knight?
I
Or
sure
you
did.
did? Excellent.
Very good. Do you understand that you are being charged with the following offense? Misdemeanor battery?
Mhm. Yes.
Is that a yes?
Mhm.
Just make sure you say yes into the microphone.
Do you understand that you have the right to plead guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Guilty.
Wait, do you understand that you have these rights, that we have the right to go to trial, but you want to enter into a plea today? So you understand that, right?
Right.
So just say yes.
Yes.
Thank you. Have you reviewed the waiver of rights form with your attorney, Ms. Wood?
So these are the questions we went over in the hallway.
Oh, yes. Mhm.
Have you had enough time to speak with Ms. Wood about all of the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
I'm good.
Are you satisfied with her services?
She's asking if you're satisfied with
Oh,
my
yes.
services.
Yes.
Ms. Wood, do you waive full reading of the indictment?
So waived.
Do you waive any and all defects in the indictment?
So waived for purposes of this hearing.
Thank you. Ms. Simmons, were you arrested on this charge?
Yes.
The state is unaware of any outstanding warrants related to this charge. Do you or your attorney know of any other warrants relating to this charge?
We do not.
Mm-mm.
Has Ms. Wood advised you of the minimum and maximum sentence for the charge you are pleading to today?
Mhm. Yes. Mhm.
For the purpose of the record, the maximum charge would be 12 months, minimum charge would be 1 day. Minimum sentence would be 1 day. Ms. Simmons, do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation, as well as no violent contact with the victim, Ms. Angela Gator. Okay. Gator is spelled Gaither.
Do you understand that's what they're recommending?
Mhm.
Just say yes.
Yes.
But the court does not have to accept this recommendation. The
Mm.
court can sentence you to the maximum on the charge. You will accept.
Mhm.
So the judge doesn't have to accept our negotiated sentence. That's what she's asking, if you understand.
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation
Mhm.
without being subject to revocation for the balance of the sentence?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes.
Do you understand that if you went to trial, you would have had the right to trial by jury,
Hmm.
the right to see, hear, and confront witnesses called to testify against you, the right to testify or to remain silent and not to incriminate yourself?
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of this charge after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
All right.
Just say yes or no.
Yes.
Ms. Simmons, how do you plead to the charge of battery misdemeanor in indictment 22 SC 180940?
Guilty.
Is this plea freely and voluntarily given with full knowledge of the charge against you?
Guilty.
Say yes.
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
In this case, do you understand that you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of the guilty plea?
Yes.
Your Honor, the state is unaware of any prior felonies as it concerns Ms. Simmons, and had this case gone to trial, the state would have expected to show that on March 13th, 2021, at 2500 Center Street in apartment C116, officers responded to a call made by the victim in this case, Ms. Angela Gaither. Ms. Gaither reported that herself and Ms. Simmons engaged in a physical fight, during which time Ms. Gaither picked up a small kitchen knife and allegedly punctured or bruised Ms. Gaither's arm with it. Officers doing the investigation spoke to witnesses. The fight spilled from inside of the house into the outside. Officers interviewed neighbors, and neighbors couldn't sort of tell officers who had actually started the incident. Speaking to Ms. Gaither, she said her and Ms. Simmons had been drinking and smoking and hanging out during that day. She had left and to go to, I think, a nearby convenience store and bought a $5 shot, came back to the apartment. While she left her small glass of alcohol on the table, she went to the ladies' room. When she came back, Ms. Simmons had drank her shot, and that caused them to have a confrontation. Ms. Simmons alleges that Ms. Gaither punched her and she retaliated. And so there is a bit of a discrepancy as to how the fight started. Officers took charges against both Ms. Gaither and Ms. Simmons. Ms. Gaither's charge was sent to state court because there was the allegation of the knife involved. Ms. Simmons was sent up here. We initially had offered Ms. Simmons diversion. She didn't want to do that. She chose instead to plead to the charge. And so we asked that you place her on the 12 months probation. It seems in subsequent conversations, they have since made up and they remain friends. They live in the same subdivision. However, we do want to encourage Ms. Simmons to have no violent contact with Ms. Gaither as they go forward.
Okay, thank you. Ms. Tucson, any criminal history for Ms. Simmons?
She has no felony convictions.
Okay. How about pretrial? Did you have anything for Ms. Simmons?
Anything for Ms. Simmons?
Pardon me?
No, I didn't have anything for Ms. Simmons. No criminal history.
Got it. Thank you so much. All right, Ms. Wood.
Thank you, Judge. Ms. Simmons is 76 years old. She is a lifelong Atlanta resident. She has family members here. I think they may have stepped out in the hallway as well.
There was a young woman and a maybe even younger person.
Yes, Judge, they
Okay.
were with Ms. Simmons.
All right.
She worked at Grady Hospital for 18 years. Currently, she is retired and she's on a fixed income. So the one ask that we would request of the court is to waive her probation fees. Otherwise, we ask that you accept the state's recommendation for Ms. Simmons.
Ms. Simmons, what did you do at Grady?
Woo. Tell you, if you pass away, if you're my patient. And there's two of them, you got to do a lot of work. But they're gonna fire me because I didn't want to carry no babies to the mall. You got to tie the babies up and tag the toe. And I told them I'm not carrying no baby. I carry a grown person.
Okay. And you were at Grady for 18 years?
18 years. Went
Got it.
to Gladys Knight.
All right.
Stayed next door.
And Ms. Gaither, you and she are on good terms again? Maybe? Yes?
Yeah, we hooked yesterday.
Is she your roommate?
Mm-hmm.
You guys, you share, like, does she, I don't remember the apartment number, C116.
Now mine C109, that's where everything happened at.
So you live in 109.
Yes.
Ms. Gaither lives in 116?
Down in the back.
Okay. So you have separate apartments?
Mm-hmm.
Okay, got it.
We hugged yesterday.
You cooked or hugged?
Hugged.
Hugged. Did Miss Gaither know you were coming to court today?
Usually time she'll call and let me know, but this time she didn't.
Okay, all right.
She ain't gonna do nothing. I ain't gonna do nothing either.
Do you have any questions about anything we talked about?
No, y'all very good.
We try. Okay. Well, Ms. Simmons, I find there's a factual basis for your plea. It sounds like you and Ms. Gaither maybe had a little too much. People got, maybe it was names or words first, but then it got physical. You're still very young, but you're at an age where you need to be careful because someone could fall and then something breaks and it gets real serious. And I don't mean a dish breaks. I mean a hip breaks.
Yeah.
And you don't need to have a broken hip. Ms. Gaither doesn't need to have a broken hip. So I hope the two of you keep hugging and not tussling. Okay?
Well, we hug.
Good. You keep that up. I also find that your plea is knowing and voluntary. And that's a fancy way of saying that you've understood all the things we talked about. Is that true?
That's true.
No questions?
Mm-mm.
And voluntary means no questions, no questions?
No question.
Okay, I just need you to say that instead of
No, no question.
And voluntary means no one's forcing you to do this. Ms. Gaither's not saying, I'm gonna get you if you don't plead. You're pleading.
No, we don't do that.
Okay, you're pleading because that's how you want to move forward.
We do some things, but we don't do it like that. We don't
Okay.
drink no more.
Got it. Okay, then I'm going to accept your plea
Thank
to
you.
the reduced charge of battery, and I will follow the recommendation. I'll sentence you to 12 months probation, and there'll be a special condition of your probation that you have no violent contact with Ms. Gaither. So you can hug her because that's gentle. But if you poke her with a knife or hit her over the head with a frying pan or anything like that, not only will you be in trouble for that new stuff, but you'll have to come back here to deal with this old case. And you know what? Like I said, you're very young, but you're too old to be messing with court. So no more of that.
Yes.
And I will also waive your probation supervision fees for the duration of your probation. Ms. Charles, anything else in Ms. Simmons's case? Ms. Wood?
No, Your Honor.
All right. So how do we do this? They're going to come today. So Ms. Simmons, you're going to need to sit tight because someone from misdemeanor probation wants to come meet you and give you some reporting instructions. You have an important date because when they say show up, you've got to show up. If you don't, then they call me to say, this Simmons woman, she's crazy. She's not showing up. Go arrest her. I don't want to do that.
Well, I want to go back to jail.
Me neither. So if you don't mind waiting here, someone from probation will be here real soon. And then once they've met with you and given you the reporting instructions, then you and your family can go.
Thank you.
You're welcome.
You're so nice. All of y'all.
Thank you. Next, I will sign that and then we will turn to our revocations.
Thank you.
Sorry, just gotta find this one document. There you go. Okay. Let's turn to our revocation calendar. So Mr. Copeland will do the hearing, may not be negotiated, but we're doing that. Mr. Buford, the state was going to think about what it wanted to do.
We're gonna reset to a full hearing.
All right. We will do that, reset for evidentiary hearing, and you will do what you think is right as the prosecutor, but you don't need to prove up all 4 of Mr. Buford's new cases. Whatever one is easiest that you think you could prove by a mere preponderance, that violates probation. Okay, just because that's a whole bunch of officers you don't need to bring in if you prioritize. All right, so reset for evidentiary hearing. And then Earl Wade was sad. We're going to handle Ms. Harris and Mr. Morgan also. Okay, then let's do Mr. Copeland, please. And just have him come to the podium.
They like chilling too hard on that. So I had to get up and come right now.
Oh, so I don't know where that thing. They saw you like your head was dipping. Like, look, man, that Miami game was a couple nights ago. You should be better by now. Okay, Ms. Rivers, are you ready?
Hey, good afternoon, Judge.
Hey, how are you?
Doing it.
Doing it. Good. Let me just make sure Ms. Rivers is good to go.
Yes, Judge, I'm ready.
Great. Thank you. Okay. Position 1 on our probation revocation calendar is State versus Mario Copeland. It's 15 SC 135142. And Mr. Copeland, I just want to make sure I've got your petition in front of me. So I'm going to open this up. It's over here. Yep, I've got it. Mr. Copeland, it is alleged in your petition that you violated probation because you in November of last year, someone went to where you were supposed to be staying. They couldn't find you there. They mailed a letter. You didn't report. The number you had left them had been disconnected. That's what I've got here. Is there a separate petition that also alleges the new CP matter, or do we only have the technical violations?
I only have the technical.
Okay, then that's good development for you.
Wow.
What is the 22 CP case about? I don't mean the facts, just what are the charges? Theft by shoplifting. Okay. So you've got an unindicted case out there. Hopefully you know about it. We're not dealing with that today. I had assumed wrongly that that was what your revocation was about, but it's not. It is, hey, you weren't where you said you were going to be, and that made it hard for probation to find you.
I understand.
Ms. Toussaint, how much time remains on Mr. Copeland's shoplifting case?
15 SC 135142 has 3 years, 3 months, and 8 days.
Got it. Was there another case he has that's open? Okay, what's that case?
15 SC 132454.
Okay.
2 years, 9 months, 26 days.
What, do you know what kind of case that is?
That's by shoplifting.
Okay.
And then there's.
What, there's more, hold on, you're gonna, and Mr. Copeland, I'm asking about these only because if you've got other revocations out there, we might as well clear them all up at once. But I don't know that I'm seeing a petition in the case ending in 454. And then you said there's a 13 SC.
Yes, 118057.
Okay,
And that ends 3 months, 50 days.
that one's almost closed out. Okay, let's check out that one. It did say there was, oh, you had your sentence commuted and then there was a warrant issued. Here it is. So Judge Kirk signed this, and interesting, it has one more nugget on it. It has the technical violations that you weren't at the residence. They sent a message, number was disconnected. But you also, it says you were arrested on January 6th of this year for theft by shoplifting, which I bet is your 22 CP case. So we do need to work through that, not meaning someone needs to prove it up, but there is an allegation in a second petition of yours for that oldest case you have that says another way you violated probation was that you were arrested for shoplifting, not that you committed shoplifting, but it may be through your lawyer, you're going to acknowledge, yeah, I was arrested for shoplifting on June 6th.
June 6th?
I'm sorry, January 6th.
January 6th.
Is that someone?
I don't ring the bell.
So any other cases, or we've got three? Three, okay. And I see warrants for 2 of the 3. There's the warrant that I signed that has the technical violations. There's a warrant in the 13 SC case that Judge Kirk signed on March 3rd. I can print it out if you need to get a copy of it. And it lists all those technical violations. And then it adds that another technical violation that Mr. Copeland failed to provide proof of completing the substance abuse evaluation. And then, by the way, he was arrested January 6th for shoplifting. So that's a non-technical violation, but that's all tied in with the 13 SC. My thought is that we try to resolve all of these together, but that's a little different than you were thinking initially.
Yes, Judge.
So if you and Mr. Copeland want to huddle for a minute, you can do that.
And Judge,
Before they huddle, don't huddle quite yet.
Okay. While I was looking, I just double check, I did send out the 15 CP case.
And on your microphone, please.
Sorry. I noticed there's another 15 CP case for Mr. Copeland. And if we're trying to wrap everything up, I would like, just to be a notice of that one as well. 15 CP 151806.
I didn't know there were CP cases back in 2015. They had invented them back then? Okay. All right. Well,
it's there.
I don't think we're resolving the CP matters today, but it's, I guess, good for that to be on people's radar if it didn't turn into one of the 15 indictments.
So this is the second, the warrant for the 13 SCP. So that was actually originally the new. Right here. See it? So that's the same as in the warrant we talked about, and then this one has the additional, the new case.
Transition treatment.
Do you want to start with one, or do you want to go back and try?
That's more for it.
Are you sure? Okay. Alrighty. Okay.
Because I was released from prison, I was saying in 2020. And only thing I remember is that my probation was supposed to start in 2020.
Okay, so you'll have a moment, you'll have an opportunity to tell the judge that, okay? Okay.
All right.
Judge, Mr. Copeland would like to move forward.
Okay, so what do you envision doing with the 2015 case for which there's no petition? Do we want to, if I come up with a revocation that's going to apply to the case ending in 142, as well as the 13 SC case, it seems like to protect Mr. Copeland so that a petition doesn't appear as he's trying to move in a new direction. I was planning on thinking, all right, what do I do with the gentleman who's violated probation in 3 cases? But there's not a petition. So you could waive his due process notice rights and say, look, whatever you're going to do, please do it across all 3 so that none of the events that were in Judge Kirk's warrant that she signed could be a basis to revoke Mr. Copeland's probation in the 454 case.
Yes, Judge. So, step back. So what she's saying is for this case, right? Petition is what I just showed you right there is the petition for the oldest case in this case. There's no one listed for this case. So if we say, if you want to have it free today, then we can say we waive it and then we'll do you want to do that? Okay. Yeah, so that way it doesn't pop up later on. You can do that.
But this is my 2015.
Well, the probation, so that's not, it's not, they're saying that you already own this probation. Okay?
So all those child and the others.
Correct, yes, sir. So there's that's what you have left in that case, this is what you have left in that case, this is what you have left in that case. Okay?
Understand.
Judge, we're ready.
Okay, so we're clear on the record. Mr. Copeland is waiving any due process notice rights as to revocation proceedings in 15 SC 132 454, for which there's not a petition,
Yes, Judge.
and 13 SC 118057, for which there is a petition, but it was not on today's calendar.
Correct, Judge.
Okay. Understanding all that, why don't you tell me, Ms. Wood, what you want to share, about Mr. Copeland and what you think is a reasonable way to resolve revocation across these 3 cases?
Yes, Judge. And then after I speak, I know Mr. Copeland is very eager to address the court.
Okay, I'm happy to hear from him, and then I'll hear from Ms. Charles.
Thank you, Judge. Mr. Copeland is 49 years old. He is an Atlanta resident. He has a stable address here. If I can read my handwriting, it's 1670 Adams Drive. Is that correct? Okay. That is with his aunt, Beverly Lynch, and he says that it is a-okay for him to return to that address. Judge, he's a high school graduate. He also has some college education. He studied journalism in college. He has 2 children, ages 12 and 14. And prior to his arrest, he was gainfully employed with a car detailing company. So
It's called Potentials Auto Detailing.
There you go. And he has informed me that he is able to return to that employment if he is reinstated. Judge, he's been in custody for 128 days at this point. As the court knows, he does have the new case with our office. He is elected to handle that at a later date. And so he has asked that the court consider revoking him for 6 months and then reinstating him to probation. And I do believe Mr. Copeland wants to speak to the court.
So I do want to hear from you, and it may be that you're the one who answers this, but let me pose the question to Ms. Wood, and then she can say, I'm going to let Mr. Copeland answer it all by himself, or she may chime in. In looking at your criminal history, Mr. Copeland, it's a bunch of theft by shopliftings. That is often, but not always, a symptom of someone who's working through an addiction. I noticed that Judge Kirk had at some point required as a condition of one of your sentences that you have a substance abuse evaluation, and you hadn't done that. And so that's one of the bases for revocation. I just want to make sure we're not glossing over that. And so my question is, does it make sense for you to be thinking about going into drug court, which is not a residential program? You could still work, but it would get you the kind of treatment that is designed to prevent there being another shoplifting and then another shoplifting. If what's behind it is a substance abuse disorder, if what's behind it is you just like to steal people's stuff, drug court doesn't fix that. And maybe prison fixes that. But usually by your age, with all the other things you've got going on, kids and a job, there's something more, like I said, the substance abuse issue. And so I'd like to hear from one or both of you how you want to tackle that, because more probation isn't the solution. You've had probation 2013 as 9 years ago, and all these other cases, and now a new one coming down the pike. And so I'm not a big fan of repeating a process that didn't seem to make a meaningful difference. But I'm kind of out of the picture because all I'm being asked about is revoking. I don't have that new case.
Thank you, Judge. And I will let him expand upon this. I do believe there is a substance abuse issue at play. The offer from the state included drug court. Mr. Copeland indicated to me that he had already participated in drug court. I don't know off the top of my head what the guidelines are for giving someone a second chance. It does sound like it was a long time ago, so I'm not sure if it was drug court as we know it today. But that was the offer from the state, and I will let him add whatever he would like to add, Judge.
Okay, one last thing before I hear from Mr. Copeland. And we skipped over this because these other cases popped up. Is Mr. Copeland admitting to the allegations that are set forth in the two petitions?
Yes, Judge.
Okay, great. Given those admissions, we got to work through what the revocation looks like. So Mr. Copeland, tell me anything you want to tell me, but include in that your thoughts about drug court and your past experience with drug court. Because if you were in drug court 20 years ago, that's not what drug court is like now. And it may make sense to look at that again. Again, it's not a residential program. You'd be able to live at your aunt's home and you'd be able to work, but you'd also be getting support and treatment that's designed to, if not eliminate, greatly reduce the chance that you'd recidivize, that there'd be a problem in the future. Your turn.
All right, first off, Your Honor, I'd like to say that I appreciate the generous offer that you have put on the table, that drug court has to offer for me, for my help, for my addiction. But I would also like to say that when I was released from prison, I immediately started working, Your Honor. But I'm not making excuses or fabricating the situation, but when I was arrested for this shoplifting, this
one meaning the one just in January?
Right. I didn't overlook the fact that I had a drug problem, but the dealership that I was working for, the auto dealership shop that I worked for, we had lost the building. So at that time, I didn't have work. So being that in the past, my drug abuse had something to do with my shoplifting, I don't know if it'll make a difference, but it didn't have anything to do with my shoplifting and my drug addiction this time. I panicked out of not being able to have finances to support for my family. And I did what I thought wasn't best, but the only thing I knew how to do, which was steal, and I'm not good at that. You can see that. So, I mean, with that being said, I mean, I was released from prison in 2020. Before I was released in 2020.
Why had you been in prison? Why in 2020, why were you in prison?
I was in prison for shoplifting.
Okay.
Which I took a 10-year served 5 in 2015. Okay, I did 2 years in prison. I was released. I stayed out a year and I went back. I caught another shoplifting and I was to be maxed out on my last 2 years. When I was released from prison in 2020, a week before I was released from prison, I was diagnosed with COVID. So they let me go a week before I was actually supposed to be responded. So when I got out, I still had COVID. I mean, to my knowledge, I couldn't remember where, who, or when I was supposed to go report to. All I knew was Memorial Drive. So I never pursued going to report to my probation. 2 years later, I get a paper in the door, which my last address I was at told me that, you got a paper. You need to go see these folks. And before I could go see them, technically, I got arrested. So now I just want to, make that brief. And, that was kind of like trying to straighten up what in between y'all didn't understand that I knew went on. I mean, I was wrong for what I did. I mean, I know.
Okay, well, that's helpful context. I appreciate you sharing that. The part I didn't quite follow is whether you believe that you are still working through addiction. What I heard you say is, look, this January thing, insofar as something happened, I'm not saying anything happened. What motivated it was, I got to take care of my family, as opposed to I got to go buy some dope. And the way I do that is I got to lift something and sell it, and then I can buy my drugs that way. Neither one is okay, and you acknowledge that. You're not saying one is good and one is bad. It's just a different reason. But if you are still in the grips of addiction, and that's going to affect your ability to work and maybe your ability to make good decisions, bad decisions, then we ought to try to get you some treatment for that, because then at 51, you're going to be back in jail because there's another shoplifting, and you've learned the hard way. Your next shoplifting, it's at least a year. It's not one of these things where a judge can waive it. It's a year mandatory here on out, every additional shoplifting.
I understand.
So if you are at risk of doing that again, because it's the drugs talking and not your common sense talking, then you may want to get treatment. But I don't know what you're working through. And I don't know what will make the most sense.
I actually thought I was doing pretty good. I mean, not making excuses, but a shoplifting still stopped, taking is still taking. No way to justify that. But I actually feel like I was doing good. I stayed out 2 years before I ever even got into trouble. I committed myself to working at this little piece of job that I did have, which was doing pretty good. And to be honest with you, Your Honor, I was not really using drugs that much. I took drugs and put it in shoplifting's hand in order as a means to supply my habit then. But when I committed this shoplifting, it was more like still wrong was wrong, making fast money to like sell some stuff to get some money to help, do what I had to do, the little bit I could do. While we weren't working at that detail shop because we had lost the business, the building that we were in. Now he has a new building, and he has assured me or told me that business is doing good. So all I was asking for was a chance to make bond, go to work, try to straighten some of this out. But the court is going to do whatever they want to do. You know what I'm saying? Whatever y'all see fit. I mean, that was my thinking. I mean, might have been sick-sided thinking or whatever, but
no,
you're the judge, so
I'm just one of the actors in this whole process, trying to make sure we have good outcomes.
Yeah, I'm not a team. It's a team effort.
It is a team effort. Have you, Ms. Wood said you told her you'd been to drug court before?
Yeah, this was like 2000, I want to say 10.
In Fulton County?
Yeah, right over there on Bellwood, right on Jefferson Street.
Okay.
That's where
like right by the prison, right by the jail?
Behind the jail.
Okay, yeah. That's Hope Hall.
I think it was like 2010, 12, one of those.
How long were you in?
I think I was in like almost 8 months.
Okay.
And something happened where I actually thought I could go to a neighborhood where I was from and not be influenced by the use of drugs. And I got high. Yeah. And what do they call it? When they throw you out, kick you out or whatever? Terminated.
Yeah.
So that's
okay.
Well,
it must have been a little more than that, because people test positive. They get high in drug court frequently. That's why they're in drug court, and we help them work through that. So maybe there's a little more to it, but so it doesn't sound like you graduated from drug court.
I didn't.
You got shown the other door.
Yeah.
Okay.
The back door.
Okay. All right.
That's what happened. So I was like, when that happened, I mean, I went to a neighborhood thinking I could, be seen and not be influenced by getting high. I got high. I went back to drug court, and they locked me up for 30 days. They let me back out. And that's when it started all over again. I started stealing. I started using more. And one big scenario led to another big scenario. And officially I was terminated.
Yeah.
And that's what happened with that incident.
What are your thoughts about trying drug court again?
I think I can do it. I'm in no hurry to get out because I'm not going to be able to get out until the county says I can go. But I think I can do it. I'm not going to say think is a weak.
No, I know you can do it. It's just a question of whether you'd put your heart into it.
Right.
Because some folks go in saying, I'm not interested in completing this. And everything just becomes a big struggle, from the basics of, hey, you got to show up to your meetings to showing up for your UA. And so I'm just trying to gauge whether you'd be committed to drug court because of the benefits it would have in terms of you being able to control the addiction rather than the other way.
I wanted to ask the court something. Would it be like, to me, it would be like, not doubting myself, juggling a ball, because like right now I have a lot of people depending on me. And
who's depending on you?
My kid's mother, my kids, and I have an auntie that's sick, the one I gave you the address to.
Yeah.
She's 88 years old and she needs help. Then with this young thug scenario, one of my nephews, he's in that. So he isn't there to help her either. So she's kind of like all alone. And this scenario with me has kind of like down her spirits a little bit too. So, I mean, you know.
My guess is she'd want you to be as clean and sober as possible and helping her out.
True.
Okay.
True.
All right.
Be around to help her at the same time.
Yep. A additional possible benefit for you is that if the prosecution is willing to do it, your unindicted shoplifting, which if indicted is the 1 year mandatory, the state may be willing to leave it unindicted to see if you successfully complete drug court, which would be an incentive for you to stay in drug court. I can't commit the state to doing that, but I would resist the state saying you need to leave drug court just to go deal with this new shoplifting, the January 2022 shoplifting. So food for thought. All right. Let me hear from Ms. Charles, who has listened patiently to all this.
And I didn't mean to do a lot of talking. I'm sorry.
No, this is your case, my friend.
Yeah.
As Ms. Woods indicated, my initial offer in this case was to try and resolve all of these cases, globally to, into drug court. Mr. Copeland has over 76 arrests, a repeated pattern of shoplifting. I hear, Mr. Copeland, that he may have a job waiting, and I hear that his auntie may allow him to come home. But what I don't hear is some sort of certainty or stability. And my fear is if we release Mr. Copeland back into the community, if there is a delay in this new job starting up, or as he says, many people are depending on him, and he might feel the only thing he has is to slide back into the old way of boosting or going into, small locations and committing this misdemeanor, takings, which sort of add up, and it's sort of a cycle that I think at this point, Mr. Copeland needs incentive to sort of try and break. And reinstatement, I don't think necessarily, 6 months and reinstate addresses that fully. I think it would be better for him to sit tight, let us work through getting him into drug court and wrap up all of his cases. So when he is released, he goes into a meaningful plan and program where we can have intensive oversight over Mr. Copeland. And so really try to redirect him from the path that he is on now.
Ms. Wood, do you know, has Mr. Copeland been assessed for drug court, or this was just something you all were talking about?
There's not been a referral yet. We talked about this in the last week.
Okay. Well, ironically, Mr. Copeland would get out sooner if he were accepted into drug court than if he were revoked for the 6 months, because I would have it be not a 2-for-1. And Mr. Copeland would have several more days before he'd be getting out from the county jail. Whereas if we do drug court, it would be that Mr. Copeland would be released to the custody of drug court once he's accepted, assuming he's accepted. And then orientation is every Wednesday. So what I'm going to do is actually ask Ms. Wood to do the referral so that you can be interviewed by the intake team from drug court. And then they'll make an assessment. I'd be really surprised if you didn't qualify. It was helpful to hear the number of times that you've been arrested and taken out of commission from being with family or working or whatnot. And that speaks even more loudly to me that we need to get to the underlying issues that are causing that to happen. And so what I'd like to do is hold off on revoking. I do find that you violated the terms and conditions of your probation in all 3 cases, the 13 SC case and the 2 15 SC cases. And what I'm inclined to do is revoke, and it will be enough time so that you don't get automatically released. So I'm making this up, but it would be revoked 5 months, but reduce that to time served upon your entry into and completion of drug court. that would keep you at Rice Street until drug court could come get you on one of those Wednesdays. You'd have orientation, and then you'd live at your aunt's home or wherever, or if you need drug court to find you housing, they can find temporary housing. Sounds like you've got that covered. You'd be able to work consistent with meeting all your drug court obligations. But if you're working, doing auto detailing, my guess is your hours can be somewhat flexible. So if you need to work later in the day because you got drug court in the morning, you work later in the day. But then we're addressing what Ms. Charles has identified, and I share these deeper issues that are prompting you, despite your desire to be there for your kids and your auntie, you cut yourself short each time because something happens and then boom, you get arrested again.
Right.
So you're either amazing at it or you really are bad if you've been arrested over 70 times. It's like every time you try, you're wearing a big red light on your head and they follow you in and you get arrested. And I'm joking, but it's serious. And you're at an age now where you ought to be real eager to break that cycle and just be out there for your family and for you, and not every 4 months, there goes Uncle Copeland, he's going back in again.
Yeah, that makes sense.
So I think that's what we'll do. Ms. Wood, if you would reach out to the intake team, and then I'll just make notes here. We don't need to reconvene because I do find that Mr. Copeland's probation should be revoked. I'll work with Ms. Tucson to get that revocation order to say what it needs to say to get Mr. Copeland into drug court. Now, in the off chance that drug court says no, I'd be surprised, and I may even have words with them about that. But if they've got a good policy reason to say no, I can't override that. Then we will reconvene just to talk about what does the revocation look like, because the state may have a view other than revoke the 6 months. But right now the focus is on trying to get you some treatment so that you can do the things you want to do without the regular interruptions of going to jail.
I understand.
Any questions about that?
No, sir.
Okay.
I understand.
All right. Thank you.
That makes a lot of sense.
Just full disclosure, I'm one of the 2 drug court judges.
Yes,
and
sir.
so it's a coin toss whether you'd be working with me or a different judge. So don't be surprised. Like, damn, I thought I was done with you, McBurney.
Yeah.
We may be back together if you get into drug court.
I'm not looking forward to that, sir.
No. It's part of drug court. You meet with the judge every few weeks.
Oh,
So
okay,
seeing
okay.
me is just part of it, or seeing Judge Krause, the other one. I just wouldn't want you to be surprised. Like, wait, I thought I was finished with you.
Oh, no, I understand.
Okay.
So I have to report, and they will let you know how my progress is doing and all that such and such, right?
Exactly. If things are going well, you actually get a star certificate and we clap. If things aren't
Okay.
going well, we figure out what we need to do. But either way, the clients meet with the judge early on. It's every other week, and later on it's once a month. It's just part of the program. Good or bad.
It's good.
Okay. All right. Thank you.
Anything good is great. Appreciate it.
All right.
Thank y'all.
So I'll submit the referral. Yeah, go with them and then we'll circle back, okay?
You bet. Can you bring Mr. Buford just to the doorway there if he's here, please?
1 year, 4 months, 6 days.
Thank you.
Is this Simmons still out there? 'Cause I had probation, I called probation.
They was out there.
They didn't come get the system. Are they still out there?
They might, I'll check.
Thank you. Thank you.
Yeah. Hey, Mr. Buford, how you doing? All right. I just want to give you an update since we brought you over here today. Your lawyer and the prosecutor weren't able to work anything out. And so we're going to reset. This is all for revocation, probation revocation. That's all it is. You've got 2 cases in front of Judge Barwick, a colleague of mine down the hall, and then 2 more cases that have not been indicted yet. And the state wants to move forward with an actual revocation hearing. So they have to bring in witnesses to try to prove up by a preponderance of the evidence 1 or more of your new offenses, either the Barwick cases or the unindicted ones. The state picks which one, they'll let your lawyer know, but it's like a mini trial. So you'll be here, your lawyer will be here, witnesses will testify, your lawyer can cross-examine them. but that's what we're going to do next. And if the state is able to meet its burden, then I need to figure out what to do with your case. Ms. Tucson, how much time is left on Mr. Buford's case?
2 years and 10 days.
All right. So the most it would be is about 2 years. The least it would be is, hey, time served and get you out of here. But the state wants to have that hearing, which they're entitled to do. And we'll take it from there. Okay. See you soon. All right. Mr. Morgan,
Yes, Judge.
and should he come to the podium?
Yes.
Great. Yep. If you're an abandoner, go ahead and abandon. Yep, right up to the podium. Okay, Ms. Rivers, you ready?
Yes, Judge, I'm ready.
Great. Position 6 is State versus Shabazz Morgan, 20 SC 175064. Mr. Morgan is here to work through a probation revocation matter. The petition alleges that Mr. Morgan tested positive for marijuana, methamphetamine, and cocaine in September of 2021. He was going to then participate in the day reporting program, but he didn't show up. He was told to report, he didn't show up, and then could not be found. So I don't know if those qualify as technical violations or not. They're important and we need to work through them. It's not new charges from what I see on the petition. Do you have any other petitions, or is that the one you have, Ms. Wood?
That is what I'm working off of, Judge.
Okay, me too. Ms. Tucson, how much time remains in Mr. Morgan's case?
2 years, 7 months, 30 days.
All right. So Ms. Wood, is Mr. Morgan admitting to these allegations or contesting them?
We're admitting, Judge. We just disagree with what should happen after admitting.
Okay. Well, having admitted, why don't you tell me what you think should happen? And then if Mr. Morgan wants to add anything, I'll hear from him. Then I'll hear from Ms. Charles.
Thank you, Judge. Mr. Morgan has been in custody since December the 17th of last year. So right at 166 days on this violation. He reports that he can return to living at, is it 737? 737 Bolton Road in Atlanta, which is where he can stay with his friend Terrell. That is also who he works with as a painter. He has a 3-year-old son that he's eager to get back out and help with. And I believe, is this your first violation?
Yeah.
He is reporting that this is his first violation of probation, Judge. Ms. Patterson, I don't believe she's still on the call. She had done some work on Mr. Morgan's behalf, and she has secured an outpatient program for him at Viewpoints. It's my understanding he can show up there if he is released and meet with a case manager and get assessed. And I can provide more information for the court if they want to hear more about Viewpoints. But that is what we're asking, to revoke 6 months, reinstate to probation with the special condition that he go to Viewpoints, actually meet with a case manager, and get an assessment done so that he can start on a treatment program that would keep him on the right track, Judge.
Okay. I just found a second petition that I signed earlier. And it lists, again, hard to find Mr. Morgan. I'm paraphrasing, but phone calls, letters. And then Mr. Morgan was supposed to show that he had submitted to a mental health evaluation and drug and alcohol abuse evaluation, and he had not provided proof of either evaluation. I don't think that changes anything you just described. And it's the same case. They're just consecutive petitions that I think maybe together more flesh out the situation that Mr. Morgan seems to have disengaged with probation as of last summer. Okay, so 6 months and then go to viewpoints for an evaluation. Mr. Morgan, why would this time be different? You were supposed to get evaluations before and you didn't. Why should I think you would this time?
When I got out of jail, the first time I was homeless. I didn't have a place to stay. I didn't have a job. Things were kind of hard for me. I only stayed out 5 months. I reported to my probation. I had what they call a step back, a setback. I did get high, and but I did stop using before I was arrested. And it's my, it's my first violation. I tested positive. I'm not arguing at that point, but this program, I think that this program would probably, it'll help me network with trying to stay clean and following up with my medications and things that I need to do. I never got to the point to where I was able to go and get the mental health evaluation and things like that. But I mean, I stopped using drugs and I found a job. I have somewhere to stay. I did accomplish a few things, And
the job is that you are a painter with the guy that you share a house with?
Yes, sir. It's his properties. He has different properties. I work for him.
Okay.
And I rent one of his properties. I'm not sharing the house with him. I actually rent one of his properties.
Got it. That Bolton Road address is your spot that you rent from him.
Yes, sir.
And then he employs you by painting his different properties.
I paint, I pressure wash. I do pretty much the things that I'm a handyman for him. I do things that needs to be done. I cut grass or whatever, and I've been doing pretty good.
Okay, got it. Ms. Charles.
Yes, Your Honor. I don't disagree sort of in principle with ADA Wood. I think where we sort of diverge is how to accomplish releasing Mr. Morgan. My concern is housing. Is a former landlord. I'm not sure how stable that is. I think I would be more reassured if there's something in writing, perhaps something more representative of where he would go. Mr. Morgan said he was unhoused prior to this, the revocation. He had sort of disengaged. It was hard to find, and just releasing him back and sort of to find his way into viewpoints. I was concerned that might not be the best way to release him back. I thought we'd be more structured. So that was our reservation as far as that goes. But what
would you propose in the alternative? Because it's one thing to say, I don't like that so much. Or what would you suggest instead?
Well, I would have liked to see something from the landlord or maybe a family member who's sort of stepping up and say, we will help. We're putting ourselves here. Here's our information. Here's our address. Here's our contact details. We're behind Mr. Morgan. And if there's any issues, probation can reach to us. And not, and that I think will give us some confidence that he will be supported this time and not just left to his own devices and fall off again.
Right, because we want to avoid officers are going to 737 Bolton Road to try to find Mr. Morgan, and someone else says, this guy hasn't been here in 3 months.
That's correct, Your Honor.
Okay.
I have the telephone number to Toray, and I got mail that came on. He sent letters from the house 737. They're on my my mail on the keyboard thing at Fulton County. It's where I stay at. I actually, I bought an automobile and it's there parked there too. So I don't plan on, that's my, and I got his telephone number if you all want to give him a call.
Okay. And you bought the car through your earnings working for Terrell?
Yes, sir.
All right. Ms. Tucson, what criminal history do you have for Mr. Morgan?
Case 15 SC 135413. And it ended in 2017 for terroristic threats, and simple assault, possession of marijuana. And then it's like 15 SC 136-143. Looks like the robbery same time. Possession of cocaine, possession of firearm, possession of law enforcement officer. Then this one here.
Okay.
Those cases were dropped.
So 2 older cases and then this 20 SC. Got it. And pretrial, do you have anything additional on Mr. Morgan?
Judge, what's the first name?
Shabazz, SHABAZZ.
Loading up right now.
Okay.
Okay. I am showing a history out of Ohio with the last, only one arrest out of Ohio, with the last being in 2018. That was for domestic violence and aggravated assault. Those cases were dismissed. And I'm showing 48 cycles out of Georgia. As far as felony convictions go, there was an aggravated assault from 2005 that was amended to a simple assault and was a conviction. Another aggravated assault from 2006, which was amended to a battery conviction. Give me 1 second, Judge. I'm sorry, I just have a toddler in here and he's being fussy right now.
Can you say that one more time?
And I'm sorry, I had to go on mute because my 1-year-old was.
Oh. Okay.
A 2012 possession of cocaine conviction out of Fulton County. A forgery in the first degree conviction from 2015, also out of Fulton County. And I do not see any other felony convictions.
Great. Thank you. And you said 48 cycles?
58 cycles out of Georgia, and then there were 2 cycles out of Ohio, with the last being in 2008.
Yep. Okay. Thank you. How old are you, Mr. Morgan?
47.
All right. So, Ms. Charles, tell me what the recommendation from the defense is: revoke 6 months and plug in with viewpoint. I'm not aware of a program. I can't mandate Mr. Morgan into a program. And that's usually what the defense lines up. So what were you, I share your concerns. And having heard more about Mr. Morgan's past and the extent of it, I want to make sure we're getting him connected with some resources and not relying on him to make those connections. But I wasn't sure what you had in mind specifically. I don't mean a program, because that's not your job to recommend a program, but how would you structure this differently?
I would, I think we can make the release into viewpoint condition upon him providing Mr. Terrell, I think that was the name, coming forwards, representing to the court, either in writing or in person, some assurances that Mr. Morgan is able to live at his home. Mr. Terrell provides us adequate email, phone numbers to the court and to probation. Also, I don't know, is viewpoints one of those where they get that ankle monitor initially? So perhaps we could release him initially.
I don't think there's an ankle monitor requirement since it's
No?
completely outpatient.
Okay.
Right.
Well, I think that would be my main concern, Your Honor, is to get someone to step in front of this and say, I will be a second point of contact for Mr. Morgan. And then once that is received, then we can release him, conditioned on that information.
Mr. Morgan, you mentioned that you were taking medication. What do you take medication for?
Take medication for major depression and paranoid schizophrenia.
Are you getting that medication at the jail?
Yes, sir.
When you're not in jail, how do you get that medication?
I go to either Grady Hospital, or I have a private doctor, which I don't have anymore. I was getting it at a place called Grow.
Grow?
Grow.
Okay.
Yeah.
But you're able to get it at Grady?
Yes, sir. I gotta remember the number. I got the number.
All right, Mr. Morgan, I wish there were more programs that were designed to assist folks in your situation, where it sounds like there may be a combination, we call it dual diagnosis. You're working through some mental health issues, but you also are working through an addiction. And it sounds like one may be more powerful than the other. In other words, the mental health situation is more powerful, but you are often taking medication that's prescribed for you to help with that. But there is a co-occurring addiction, because you mentioned you tested positive. We got some prior convictions where you had drugs. The combination of those can be problematic, which would explain why you've been arrested at least 50 times in your life. That's a lot. I'm anxious for you to not have that happen so often in your life. But I don't have a place to send you where you could get the help that hopefully you want, but that you definitely need. I can make it a requirement of your probation, which I will, that you submit to this evaluation, but that's about as far as I can go, unfortunately. So, Mr. Morgan, I do find that you violated the terms and conditions of your probation in 20 SC 175064. You did so in almost every way you could on the technical side. So not a new case, which is good. You didn't go get arrested, but you didn't get a mental health evaluation. You didn't get a substance abuse evaluation. You effectively disappeared. They come find you. You tested positive. All the things that make us worried that you're going to get arrested again, and then you'll be sitting in jail, which doesn't help you. And it doesn't help Mr. Terrell if he needs you to be working for him.
I understand that I wasn't out but 5 months. And then the time that I was out, I did report to my probation officer. And I mean, like I still have to find somewhere to stay. I still have to, I got my son, he still wants things, he still needs things for the house. And
where is your son? Is he with his mom?
He's with his mother right now.
And is she in Georgia?
Yes, sir.
In the Atlanta area?
No, she's Cummins. So, I still got to get a job, secure a job so that I can have a place to stay, so that I have a place to report.
Yep.
You feel what I'm saying? So, I mean, I'm not saying that I wasn't going to get those things that you wanted me to do. I didn't have time. I didn't have enough time to do it. And then, like I said, I tested positive one time, but I stopped using before I got arrested.
Okay.
So, I mean, it's like,
Well, what I'm going to do, Mr. Morgan, I'm going to revoke 8 months of your probation. You'll get credit for the time that you've been in. I'm going to add as a special condition that within 21 days of your release, you submit to an evaluation at Viewpoints. So you got 3 weeks to make it happen. That needs to be a priority. And you will be a special condition of your probation that you follow whatever recommendations they have after they do the evaluation with you. So if that means you're going to see a therapist every so often, or take a different medication or this or that, that's going to be something you need to do. It will be a special condition of your probation that you take all prescribed medications. You've told me that you're taking medication right now to help with depression and with schizophrenia. So you'll need to continue to take those medications if a doctor prescribes them, which I assume a doctor will continue to do. I'm going to ask probation to assign to you a mental health probation officer. So it's someone more attuned to some of the things you may need help with. And that's as far as I can go. You do need housing, but I can't make a condition that you get housing. You're going to do your best to find housing. There are resources out there, and I hope that you make good use of them. But it is hard, and you were working hard to get a roof over your head, get a car, get a stable job so that you could focus on the people you care about. You got to start with you until your house is in order, meaning you're getting the treatment you need. The other folks can't, in the end, rely on you because you'll get arrest number 51 or 52 and you're taken out of their life and everything resets. So I think you are trying, but you are certainly going to need to let Viewpoints spend some time with you so they can figure out ways in which you can be supported. Does that make sense?
Yeah.
Any questions about that?
You're saying you're gonna revoke 8 months of my probation.
I did.
And then you're gonna give me 21 days after getting out to go to Viewpoint?
Correct.
Okay, so, okay.
So I'm writing that down for you so that you won't forget, okay?
Okay.
You'll also, and you're going to hear from Ms. Tucson in a minute, you're going to need to report to probation after you're released. And the probation officer assigned to work with you will be reminding of you of these things as well. Hey, how you doing with that Viewpoints thing? You taking your medications, things like that. This is someone who's not just a nag, but it's someone who's checking in to make sure you're doing what you ought to do to take care of yourself. Okay? Ms. Tucson, what do you need to get from Mr. Morgan?
If you stated 737 Bolton Road, do you want that on your file?
Yes, ma'am.
And that's Atlanta?
Yes, ma'am.
Okay. And you stated, do you know where probation is on Memorial Drive? I can give you that address.
I would, yeah, I would appreciate it.
And just that when you're released, make sure you report 48 hours to probation.
So you're getting 2 copies with it, okay? So
Okay.
don't lose them.
Okay.
And that's my number.
Mhm.
Call me with any issues. Leave a voicemail if I don't answer.
Okay.
This is Viewpoint's number.
Mhm.
And then this is Fulton County Probation Office, address in the back. And then she's also going to give you the reporting instructions, okay?
Okay.
All right, here you go.
These are the reporting instructions. Yeah.
Yes, ma'am. Thanks a lot. Okay. Mhm.
Okay.
Is Ms. Harris up or do you need to, she is up? Great. Okay. Can you put the petitions next time in the,
I noticed that I did.
that's okay. It was a tough one. Mostly just put the calendars in there. So Ms. Harris, AKA Ms. Bryant, has 2 open, well, unindicted aggravated assaults.
Yes, Judge.
Okay.
She said she wanted to move forward with only the revocation today, so if that changes.
She's the boss. All right, I've got her petition. Oh, it's basically one of the aggravated assaults. All right. Good afternoon.
Okay.
Hey, how you doing?
I'm okay. Should I call you Ms. Harris or Ms. Bryant?
Miss Bryant.
Ms. Bryant, I will do that. All right, well, we're going to go on the record. In your case, it is 19 SC 164594. And the style of the case is State versus Linda Harris, but we all know you're actually Andrea Bryant. So I'm going to call you Ms. Bryant. I'm Judge McBurney.
How you doing?
I'm doing all right. How are you doing?
I'm blessed.
Good. Well, that's a good way to be. I signed a warrant for you back in May of last year. It's about a year old, this warrant. And it alleges that you violated your probation in a theft case by getting mixed up in a new, it was new back then, aggravated assault case. That case is unindicted, but it's out there. And we need to work through what the consequences of that arrest ought to be for your probation. And before you came out here, Ms. Bryant, I learned that you've got a little less than a year and a half left on your probation in this theft case. So what I'm going to do is ask Ms. Wood some questions. There may be a few things you want to add if you want. You don't have to say anything at all, but you'll get a chance. Then I'll hear from Ms. Charles, the prosecutor, and we'll make a plan. So Ms. Wood, is Ms. Harris, Ms. Bryant, is Ms. Bryant agreeing that she was in fact arrested by the Atlanta Police Department in April of last year, 2021, for aggravated assault?
Yes, Judge.
Okay, that's the allegation. So she's admitting to the allegation. And what are you recommending on Ms. Bryant's behalf ought to happen?
Judge, Ms. Bryant is 56 years old. She does have an address here in Atlanta, 234 Memorial Drive Northwest. She has 3 children. She has an 8th grade education, although she has completed her GED. Prior to her arrest, she was working for her sister, doing cleaning jobs and food delivery and other random jobs, Judge. She has indicated to me that she would like to handle the probation revocation today and then deal with those two new cases at a later time. I have a feeling Ms. Charles is gonna add some context for the court on those new cases. Miss Bryant has been in not even a month yet, Judge. It looks like she's been in for about 27 days. Does that sound correct? And so we're asking the court to consider revoking 6 months and closing this case out. And if you want to add
Okay.
anything, I'll let you talk. Okay.
I am just looking up one thing. Okay. Ms. Bryant, what's it 234 Memorial Drive? Is that an apartment complex?
Yes, sir.
And you've got a spot there?
Yes,
Do you live with someone or is it your own place?
it's my own place.
No roommates?
No roommates.
Okay. You've been away from there for a little bit. You think it's still there for you and why? Who's been paying the rent?
I have a signed lease and I pay by my income, and I don't have an income right now but food stamps.
Okay.
So the government pay for my rent.
Got it. Okay. Ms. Charles, what are your thoughts about what we ought to do with Ms. Bryant's situation?
Your Honor, I'll ask the state, I'll ask the court to revoke the entire balance. She has 1 year, 4 months and 6 days left. Ms. Harris, or Ms. Bryant, sorry, has 2 open cases. Both of them involve the same victim, Mr. Johnson, on 4/7/21. Ms. Bryant was arrested for hitting and assaulting Mr. Johnson with bricks in the face. She was granted a bond less than a little bit over a month later in May of 21. She assaulted Mr. Johnson again by stabbing him, hitting with a cane. She's currently being held on no bond on that case. Mr. Johnson has since come here into the courthouse to speak to myself and our victim with his advocate to talk about how he's afraid for Miss Bryant. She repeatedly assaults him. They did have a relationship before. Initially, he had tried to help her, but she keeps attacking him. And at this point, it is better that they stay separate. Since the cases are unindicted, I'm fearful for Mr. Johnson that if she's released, there might be some lingering anger issues and she might want to go, re-assault or re-offend and want to avoid that. So I think at this point, it is better to keep Ms. Bryant in place at this time.
Okay. Ms. Tucson, do you have any adult felony history for Ms. Bryant, Ms. Harris?
The current one she's on probation for now. Let's see. 02 SC 11069, death by receiving. 03 SC 04441, Fulton County burglary. 07 SC 57640, death by taking. And this one's the count, 12 CR 433710, forgery. And an older case, Y22047, possession of cocaine. And C35735, possession of alcohol.
All right. And pretrial, how many cycles do you have for Ms. Harris / Ms. Bryant?
Showing 37 cycles.
Okay. Anything out of state or all Georgia?
Georgia.
Okay, thank you.
You're welcome.
So So Ms. Bryant, at some point in time, you and Mr. Johnson were friends?
I tried to help him and where I stayed at, and he wanted me to be his girlfriend, but I didn't want to be. And I had got my stimulus check, and he tried to take some of my money, and I defended myself.
Okay, I didn't mean for you to go into lots of the facts. I just wanted to make sure Mr. Johnson's someone you know.
Yeah, I know of him.
Okay,
Yeah.
got it. All right. Ms. Bryant, do you take any medication right now?
For my ulcer.
Okay. Anything else?
No, sir.
Just for physical health, no mental health medication?
No mental.
No? Okay. Have you in the past?
No, I've been diagnosed, but I didn't take the medication. I didn't need it.
Okay.
I just had therapy.
Okay.
Someone to talk to.
How long ago did you last have therapy?
I just got out of the hospital about a month ago, and they gave me an assessment in there. We were just talking.
Okay. And were you in the hospital because of the ulcer, or you were in the hospital for something else?
For the ulcer.
Okay. And that's when you got the assessment?
Yeah.
Did they recommend that you get any counseling or treatment?
No, sir.
Okay.
Not unless I want to.
Got it. Okay. All right. Ms. Harris, the allegations here are that you got arrested for the first aggravated assault, which is the one I think involving the brick. The second one didn't make its way onto any petition. But rather than you getting tripped up by that coming later on, what I'm going to do is revoke 1 year of your probation. You'll get credit for all the time that you've been in, and I'm going to suspend the balance. So you won't be on probation anymore in this old case involving something stolen. And going forward, you'll just have these two open cases that I assume the district attorney's office will indict at some point, and you can work through those, but your lawyer will be able to let that judge know that there's already been something of a penalty for you because you had this revocation, and the basis for the revocation was one of these aggravated assaults, and that may help resolve those. Ms. Charles, anything else for the state?
No, Your Honor.
Ms. Wood?
No, Your Honor.
Okay, good luck, Ms. Bryant. Nice meeting you.
All right. Yeah, go.
I think that's it. Thank you, pretrial, as always. I think we had two different pretrial people over the course of the day, but that was all good. Thank you, Ms. Tucson. Ms. Rivers, hope you're feeling better.
Hey, Judge, thank you.